We're back, everybody. Grace and peace. Happy Monday to you all. Now, if you've been keeping up with this YSL case, you know why today has been so, I don't know what to say. It's been amazing. But before we jump too far ahead, I do want to say thank you all for stopping by. I think we have a whole bunch of slew of new guests stopping by today. So please make sure you hit the like button. Come on in and join the best live chat on the planet. My name is Dear Woke Christian, and we're gonna go through and discuss this YSL case with you all today. So some of you might really have a high functioning knowledge on this, and some of you might be the first time you ever heard about it. But hopefully today we can bring it all around and hopefully make some sense of it, because it is pretty wild. So first of all, thank you so much for stopping by. And I appreciate it. Looks like we got some good folk already in the chat. Good to see my good friend Retired in the building. Republic Room is in the building as well. Cat, not Williams team is already showing up. He's new here from the Cat Army. I absolutely love it. And Jess is here. How are you doing? Good to see all of y'all. Make sure you say hi. Hit that like button and go on and say hi. You're a part of the best live chat on the planet. But before we go too far, people, I got to tell y'all something. As we get kind of settled in, I promise this won't be long. It won't be long. Today, Dear Woke Christian did something I've never done before. I absolutely, positively have never done this before. What is this that you've never done before, Jason? You're a whole grown man. What is it that you've never done? I've never gone to IKEA. I've never gone. Never been. Today's my first time going. And I will tell you this emphatically, everybody, I don't know I can't promise you that the word IKEA is translated correctly, because I'm pretty certain that word means hell. That was the worst experience I read in my life. Absolutely worst experience in my life. You walk in there and it is a maze of dead ends and tchotchkes and things that are misspelled. It was totally, unequivocally insane. I don't know how people do it. I have no idea how people do it. Because you think you're going one way, you think you're going to find, like my wife and my daughter were already there. So they were already lost in the labyrinth, right? And you think you know where they're going. They tell you, oh, we're here. We're near this thing. You're like, okay, yeah, let me find it. Nowhere to be found. I found the meatball section, or whatever the little cafe thing is that everybody's raving about. I don't care. That was insane. I'm sorry. I'm pretty certain that Dante saw into the future, and when he wrote Dante's Inferno, he was writing about IKEA. I promise you. Absolutely. It was the craziest thing. And by the way, why is everything in there spelled so crazy? Why? Please explain it to me. This furniture that's in my garage right now, by the way, it comes in 19 boxes. The one desk comes in 19 boxes, and each one of the boxes has a slew of letters, and I promise you they're speaking in tongues. That was the craziest thing. So why do they do that? Oh my gosh. All right, now why did I bring all that up? Because IKEA, in my mind, is exactly like the YSL case. You think it's going in one direction, and they throw you a Mickey Flynn. You think it's going, you're walking down a path of seeing justice served, and lo and behold, you find something else. Now, in order to help me make sense of this, I have a friend of mine who, she said she's been to IKEA a time or two. She can help navigate this craziness. But more importantly, I need her to help me navigate this craziness, which is called the YSL case. So ladies, with no further ado, and gentlemen, with no further ado, let's bring Cat Not Williams in the building. How are you, Cat?
Hi, everybody.
All right,
it's interesting to be on this side.
All right, now tell the truth now. Do you shop at IKEA?
Look, I don't live near one, but if I was near one, you got to make a whole weekend trip, plan a whole Saturday to go.
Never gonna happen. It's never gonna happen. That was the most tumultuous experience I've ever had in my life. I mean, why does a desk come in 9 boxes? That's crazy, and they're heavy boxes too. I'm like, great day. These things are stout. It's a desk. Anyway, it's Cat Not Williams, ladies and gentlemen. Please, if you don't mind, introduce yourself to us. Tell us a little bit about who you are and about your channel.
Well, I'm Kat Wagner, not Cat Williams. You may have heard that joke where I had to change it. My name used to just be Kat. And every time someone started talking about Cat Williams in a chat room on YouTube, it would be a flood of orange name tags. And I was like, are they talking about me? So that's how I became Cat Not Williams.
I love it.
But me, Not too much with me, you know. I like to hang out. I like to look at law. I like to look at a little bit of news. I don't get too political, but unfortunately, they're interwoven.
Yeah, yeah.
Um, and on the weekends, I like to cook. I really love cooking. I love to listen to you while I cook.
Oh my gosh. Well, I appreciate it. Thank you so much
Yeah.
for that. I'm glad to have you. Now, we've been talking inadvertently through email as well as through the chats about this YSL case. And it has been is it fair to say it's been a dumpster fire? What would be your assessment of the situation?
My assessment is everybody needs to say a prayer for Nicholas Starro, who's been covering this case from gavel to gavel, plus all the pretrial stuff going on.
Really?
There's no
Wow.
way. There's no way. Can you imagine?
I can't. I can't. I said I was going to go down to the courthouse 'cause I live here in Georgia, in Atlanta. I said I was going to go to the courthouse, and I still haven't made it down there. Well, and now I can't. But yeah, I'll be praying for Nicholas because I can't imagine doing that at all.
Yeah, it's a lot. It's a lot.
So, what is your overall assessment before we jump into like some of the deeper issues of it? What would you say would be some of your assessments of what's been going on in the case so far?
Well, I've got to preface my top level, and when I was younger, I didn't really see it this way. I used to think, hey, if someone's in jail, they must be there for a reason. Do the
For
crime,
sure.
do the time, like that type of mentality.
Yes.
Until I started going through high school and college and realized that you can't just take that type of phrase for granted. Like there's plenty of people, and I'm well aware now. There's plenty of people in jail and in prison for things that they didn't do, things that they're innocent of. And when I look at something like this case, you've got 26 people that are charged and indicted, and they've been dealing with this for years. Some of the information is going back more than a decade. And all I can think is if we're putting that much on the line, the process needs to be followed. Like there needs to be integrity
Yes.
to the process.
Absolutely.
And so from a top level view, it almost sucks to say, but with all the shenanigans that have gone on, it's honestly enough to overshadow a possible guilt of
Hmm.
any and all of the defendants. And we should never find ourselves in a situation where I'm not saying you should say that, but me personally, I think the stuff going on is so egregious that it's almost becoming irrelevant to me if any or all of the defendants are actually guilty as charged.
I agree with you 100%. And I keep saying if the case is clean, then go ahead and try it in a clean manner. You don't need to, and you should not be seen doing things that look, again, underhanded, that look like it's not a clean case, because that only lends itself to people doubting and second guessing and looking at you side eyed about the findings of the case. So when you do things like this, and I think it's fair to say, in my opinion, it really escalated with YSL Bean when Mr. Bean got on the stands, and that's where, really, in my opinion, and I admit I wasn't watching the 60 other days before then intently, but with Bean, to me, it really hit crazy town with just how passionate that man was about, hey, y'all are harassing me and I've already let this go and I don't remember, and so on and so forth. And I really started looking into it. I'm like, man, if this is a clean case, why are y'all doing this? And why are y'all behaving in this manner? And to me, I think I think what happened today only goes to show what you're saying and what I'm saying, that it has to be done correctly in order for you to get the right kind of outcome, the correct outcome, because it's not just the outcome that I want, but the outcome that is right in this case. Do you agree with that?
I agree. And I'd say when there's multiple instances of something, is it incompetence? Is it a mistake? When you see something happen once, okay, sure. But when something happens, and this is a case with multiple co-defendants, so every time a mistake is made, if it's an innocent mistake,
Right.
there's 6 defense attorneys saying objection or we filed a motion. They're telling you why it's wrong. So when there's still the same pattern occurring at multiple instances after the first time the defense has called it out, and then again after they've called it out the second time, and then again after they've called it out a third time, then it's an integrity problem. It
Right.
seems more reasonable to conclude that the issue is the integrity and not just, a brief moment of incompetence or, a mistake, an innocent mistake.
I agree 100%. So what I want to do, let's see if I can pull this in and do this correctly. Let's try it. Did you come in? Did it bring you in? It did not bring you in correctly. All right, let me bring Kat in. Got to bring Kat back in. We were going to look at an article, but I think Dear World Christian has bogged it down. I might have ruined it. Why is it not showing your picture, Kat? Let's bring that back. That is not cool. All right. I've just proven to everybody that I have no idea what I'm doing technologically. All right. So it wouldn't share my screen correctly. Were you able to see it?
No.
Yeah, I got a tech problem. All right, let's figure it out. Give me a second. So give us a highlight of what happened on today. I mean, today, funny enough, is the 100th day of this trial, which has been the longest.
Right?
This is the longest trial in Georgia history. Dare I say, probably say the biggest at the current moment. The largest and the biggest trial. And it's in Fulton County. Y'all know what's going on in Fulton. So give me a high view of what is actually happening in that you understand.
So was your IKEA trip like a 100-day celebration? Is that why you ended up making your plan to go there?
Oh my gosh. I'm sorry. There's a lot of people in the chat saying they love IKEA. I'm sorry. Every last one of y'all is in 0-second timeout right now because that place is not appropriate. Oh my gosh. Okay. No,
but I do have like a real quick roundup for anyone that missed day 100.
Let's do it. Let's go.
Now, you guys know for the last week, the jury has been out of court. They were expected to come back in on July 8th. That's not happening anymore. The trial is on pause indefinitely. I'm going to tell you why. Today, it was scheduled. There was going to be a conference in the courtroom. It was going to be in camera, which is a Latin term. It doesn't mean in the view of a literal camera. It actually means outside of the view of the press. Right. So this is kind of going to be a private meeting that the attorneys could be present for, but we weren't supposed to be able to watch on a law and crime stream on YouTube. But judge changed his mind at the last minute. Think about why he may have done that. But what happened during this conference? It went just short of an hour. Judge Glanville says he will release the transcripts from the ex parte meeting, and he says he's going to release them in full. He also makes it clear that they were not prepared 2 weeks ago, but suddenly somehow he's preparing them now. All recusal motions will be heard by another judge. On Friday, you may have seen that Doug Weinstein's motion, he's the attorney for Yak Gotti, he refiled the motion he filed with the Supreme Court of Georgia with the Superior Court of Fulton County. And when we pulled up that case number, we saw it was already assigned to Belinda Edwards, a different judge in the Superior Court. Now, Glanville didn't really acknowledge that today. He made it sound like he's the one making the decision to send all of these motions to recuse to a judge other than himself, even though he refused to do that for the last 2 weeks. One of them was already assigned, but it is true he has to send the others. The one filed by Brian Steele and Keith Adams, as well as the recusal motion for Brian Steele's contempt order and the recusal motion filed on behalf of Kayla Bumpus. Now, the show cause hearing that was supposed to take place on July 3rd, that was rescheduled last week at the last minute for Kayla Bumpus and the ex parte participants, members, attendees. That's completely canceled. And likewise, the motion filed by Kayla Bumpus to quash the show cause order is now moot. However, Judge Glanville responded to one of the attorneys representing Ms. Bumpus saying, well, it's moot for now, so you don't need to bring that up now, but maybe at a later date, if it becomes relevant, you can argue it then. So on one hand, he's making it seem like it's canceled, but then he's saying it could come back up. So who knows with him? Glanville also seems to have been making a bunch of case law arguments, reading case law that he says supports him, reading it out loud in court today, so it's on the record. And then Glanville also clarifies that he was making no assertion that Bumpus violated attorney-client privilege or her candor to the court. But he doesn't say she's in the clear because 2 seconds later he suggests that the Georgia Bar or the Supreme Court of Georgia could still find an issue with Kayla Bumpus's behavior. So he distances himself, but does not really exonerate Kayla Bumpus. And then We also get a time frame. I think the most significant thing we got from Glanville, and I have to pull up my notes. So as he's talking about the transcript, he gives us some time frames. He says that the ex parte meeting on June 10th started at 9:10 a.m. and it went until 11:31 a.m., right? So that's just a period of 2 hours and 21 minutes.
Mm-hmm.
Woody didn't arrive until 10:03 a.m., so almost an hour after the transcription apparently says that this meeting was called into chambers and started. The meeting, after Woody shows up at 10:03, stops at 10:17. So 14 minutes with Woody there, and it stopped so Woody can speak to his attorney, Caleb Bumpus. The meeting resumes at 11:28, and then only goes on till 11:31. So according to Judge Glanville and how he's presenting these timestamps, and this is his presentation of the timestamps, the total time, like, of that meeting with Woody in there,
it's like 30 minutes.
Was the 14 plus 3 minutes, 17 minutes.
Yeah.
Plus the block of time from 9:10 to 10:03 when Woody wasn't present, but they were still in a meeting without Woody for whatever reason. So I'm not really sure if I believe those are the accurate timestamps. Although, you know, Kayla did say she didn't speak. She doesn't think she spoke with him for near an hour. She said it was a couple minutes. So.
No, I'm worried about that as well. I'm not saying that Judge Glanville is lying. I just think that he might be being very creative. He's already shown us that he has very little understanding of time, because he'll say a 5-minute comfort break and it'll take 45 minutes. So it's fair to say that he doesn't have a good grasp of time. So if he's that out of pocket, then I don't suspect that he's correct there. I just hate that, again, just to the point that we were making before, you want this to be as above board, especially a trial of this magnitude. We're not talking about the chronic jaywalker gang. We're not talking about the chronic bird scooter gang of Atlanta. We're talking about what you're saying. You're saying that these gentlemen were involved in drug trafficking, murder, all types of crimes, and such of that nature. Shouldn't you want this to be as above board as possible, so not to have any kind of semblance, or dare I say, the odor of mendacity involved in this at all? Because it just seemed like Glanville doesn't care. Like, oh,
who knows? Because they gave the immunity deal to someone that was like Georgia or Atlanta's top 10 most dangerous persons at one point in time.
Yeah.
Because Woody made that ranking, and now he's the one with the immunity deal.
And dare I say, and again, I don't fully understand all the ins and outs of how a star witness is selected. So I will be honest in that regard. But man, if this is your star witness, why in the world? First of all, why in the world is this your star witness? But as we saw for the last 2 weeks, the whole going through the interrogation, this guy is clearly playing you. He clearly is playing you. Whether he was playing the investigators or whether he's playing you now, somebody's being played. And dare I say, it might be all of y'all. So why is this guy as you said before, the Atlanta's top dangerous person? Why is he your star witness? Like, good gracious, could you not find a Sunday school teacher to be your top witness? Anybody? Good gravy.
One of my favorite moments of this trial, and I know a lot of people have tuned in because Woody's highly entertaining, but I cannot get over that exchange where Hilton's trying to probe back and forth. I don't think she understood he was outsmarting her. She was perceiving him as dumb, less intelligent than her, less slick than her.
Right.
And he goes through this conversation trying to explain what he means when he says, I tell the police, anyone questioning me, whatever I think that they want to hear.
Yes.
And I might do something to buy myself time so I can think of a story that they'll believe. And he even goes so far to say, like, Detective Gaither, you know, she kind of saw through a little bit of that. I had to come up with things a little bit more for her. But he gives the example of, well, you know, I'm going to make small talk at first. I'm going to give a little truth. That way it's easier to digest the story that I try to tell.
Mm-hmm.
So I might say, if they ask me what color the sky is, I'm going to say the sky is blue. And then he starts making the conversation about Kristen Weaver, the court reporter, her shoes. And he's like, well, they're white, they're tennis shoes. And Miss Hilton's like, so that's true. And Woody just looks at her like, are you not getting it?
And I agree. She totally missed that. And I'm not trying to say anything about Simone Hilton's ability as an attorney, because I've heard Kayla Bumpus say that she's a really good attorney. And I think she's trying her best. She was dealt a really horrible deck of cards in the respect that
100%.
she had to deal with this case. However, in that regard right there, he told you, I do say things that are true. It's not like he's going to tell you a lie all the time. The sky is purple. He's not doing that. He's going to tell you truth. So when he said the woman's shoes were white and you said, well, that's true, you did kind of miss the point that he's saying. Like, he's telling you that, sure, I'll tell you a truth every now and then just to keep you on the hook. And I think you made a great point there, because this has been on the hook for sure.
Well, and it's their star witness, and one that they are trying to introduce key evidence that they need for other witnesses that they haven't called yet. They need this footage to come in. They need the foundation to be laid, and they were struggling. Do you know this person you're in a picture with? No, I can't see. I have vision problems. Like, he's not laying the foundation. He knows to avoid laying foundation.
Yeah.
But this is your star witness, and one of the angles you're taking with him is impeachment by contradiction. You're well aware that he contradicts himself to a point where it's consistent, it's strategic on his end throughout this scope of 8 years that you've been looking at him.
Right.
And yet you completely miss it when he's trying to show you how he uses contradiction in his police interviews. Right on the stand, he tells you his formula for it. And it was just one of those big misses that, all I could say is, like, I felt like Hilton lacked, like, the street smart, the intuition.
I think that's a very good point, because somebody mentioned it, like the DA's office should spend some money, since they had the gang prevention task force that they quashed when Fonnie Willis came into office. Then they should have used that money to at least do like a gang, what do they call it? A gang vernacular training, so that they could at least be up to speed on what's being said by gang members or potential gang members or possible gang members, so they at least understand how they think. Because I don't think Hilton realized just how corrupt Woody's thinking is, and how her mindset is not even on his plane. So when you're asking him a question, he does seem like you could have easily said, oh yeah, he's just being dumb. No, he was being extremely smart, and you got played. So.
Yeah, and it'd be different if this was a 2-week trial, and he's like maybe he observed one thing or another, he said one thing, but this is something you're hinging charges on over 20 people in relation to something that he said. And we've got like almost 2 days worth of footage that they've narrowed it down, but you have all of that, and you didn't come prepared for this witness of all witnesses.
And this is your star witness. This is not the defense's witness. This is the state's witness. And he's this out of pocket. They should have just said, hey, we're going to call a pinch hitter or something. We're going to shift our witnesses around a little bit, because we need to work with Woody. And I've talked to people before, like, hey, why do you think it is that he came in so unpolished? He came in so unprepared. Like, wouldn't you have at least exposed him to his testimony before and say, hey, this is what you said? Or this is your deposition from so many years ago or whenever? Because it seemed like, again, maybe he was just playing everybody, but it seemed like he was not aware of what he said before. And did you not give in? And I feel comfortable that he wasn't aware of it, because the way Hilton responded, as if she really truly expected him to have remembered what he said 8 years ago, in a fit of rage or whatever like that, after somebody just shot at you. Like, what did you think then? Sir, ma'am, somebody just shot at me. So, and somebody just said, Woody didn't come here to lose. Woody did not come here to lose. And he did not.
Well, and I think he's going to end up being the defense's witness, because,
oh, no question.
Cross-examination is going to be fun. We are going to see like huge viewership numbers on the day that cross-examination starts. It might be a month out now, because we have to wait, the trial's on pause indefinitely. But, the defense hasn't raised hell about Woody being on social media talking about the case while he's sworn in as a witness. If you think about the Johnny Depp trial, there was one witness. It was Johnny Depp's manager's wife, Gina Deuters, who travels with them, has a lot of firsthand dealings with both him and Amber Heard in close proximity, private matters. And a reporter named Eve Barlow falsified an Instagram picture where she changed the date of a post that was talking about the trial. Something that Gina Deuters posted before she was subpoenaed as a witness. So you can still talk about things until you're under subpoena.
Right.
Changed the date, and then they asked her about it, and they're like, well, have you been looking at this case on social media? And she truthfully said, I saw stuff online. So she did give a truthful answer, and they had a reason to take her down because she saw information about the trial online. Wow. But that image that they used to get her questioned in the first place was falsified. And then here you have Woody posting pool pictures, posting like, I'm not scared, I didn't do it. And the defense isn't saying get him gone, he's doing this. Mm-mm. And like, what if the prosecution wants them to? What if the prosecution's looking for an out? Like, and the defense is like, no, we want him for cross-examination. Like, where are we at now?
So in your opinion, just going from your opinion, you feel like this train will get back on track, heading whatever direction it is in. Is that your assessment, or?
Well, I think Woody's going to steer the train. He's the conductor as long as he's on the stand. So if the direction he decides to go in could coincidentally be favorable for the defense through cross-examination, that's just coincidental. I think it's going to be Woody taking in that direction.
I love it. So you feel, okay, so as it relates to Glanville being recused, because in my understanding, if another judge is looking at this, and in my opinion, it seems like a cut and dry, Judge Glanville made wrong decisions and should be recused. I don't think he gets to start back up from, station 9, or I'm sorry, station 100. I thought it had to go back to the beginning, but I might be wrong.
I couldn't actually find any, procedures for Georgia. Other states have things that are outlined. If a judge becomes incapacitated or unavailable for any reason, right? They could pass away. They could become terminally ill. There could be some other type of emergency or recusal. Any reason that a case would have to transfer between judges after something's already started. It's not that that's never happened in the history of this country, right? There's no way that a judge has never, whatever. Yeah. But I don't see anything specifically outlined as a process or procedure in Georgia as to what happens if a judge becomes unavailable for any reason in the course of a trial. So I'm sure there has to be something that I'm just not able to pull up easily, whether it's in case law, if it's not codified somewhere. There has to be something. But what I really think is a separate issue, the recusal is one thing, but the issues that Judge Glanville's being challenged with now are things that the prosecution was there for. They were a participant in. In fact, they're the ones that requested the ex parte meeting in the first place.
Got it.
Hilton requested it that Friday. Glanville was like, no, we're going home. You know how he likes to get out of court. And it was a Friday afternoon.
Yeah, he had to get out of here.
Gotta go. But Monday morning, they have this meeting at 9:03 a.m. And when you think about that, the same issues that they're holding against Judge Glanville, it's the prosecution was there. And if that stuff is found to be true, if someone takes what's being asserted in these affidavits as true, then the prosecution has unequivocally engaged in prosecutorial misconduct. That's where you get your mistrial, and retrial would be barred.
I agree.
That's where you don't even start back at, if
Zero.
The prosecution has to recuse for a reason other than misconduct, that would have to go back to zero. I don't imagine how, I don't know any state that would let.
But if the judge had to recuse because of poor behavior and doing wrong things, would that not also? That's the part where I'm not 100% certain.
The problem is,
go ahead.
Can they have him recuse, cut the cake in half, and give both sides a piece of cake? He recuses, but we find it as an appearance of a conflict, right? Rather than all of these things actually occurred. Then we're not really finding true judicial misconduct that would warrant a mistrial barring retrial. We're just finding he should recuse himself because on the surface it looks to be like there's an appearance of a conflict here, right? So there's a way that they can have him recuse himself where they're not really laying down the hammer all the way if we take at face value what these affidavits assert, what these affidavits say that they believe on information and belief to be true.
Right.
So
Okay.
You're right. If they do make the finding all the way, if they go all the way and say, this is messed up, not only does he need to recuse himself, but this warrants a mistrial, then yes, that could happen. I'm not sure if I think it'll go that way, though.
Interesting. Okay. Well, I'm going to see if I can make this go the right way and bring on this. We want to hear what he had to say before we read the proffer. So let's see if I did this right. I don't think I did. All right. All right. So let's do this. And we're going to bring in a camera. That's me. And bring in another camera. I'm telling y'all right now, man, we are struggle streaming over here. All right. How about that? Can you see it?
So I don't see it on the screen.
Why
On
is it
YouTube,
not
I
showing?
see the screen. I see me giant in the background with a little bit of the screen. Oh, I see a green screen in the back and then a clip
Yeah.
of Long Crime.
Why is it not allowing you to see the screen? I tell
And now
you.
I see two of you. Switch one of you with me.
Right, got that. YouTube is slightly delayed. It's a few seconds delayed.
Okay, now it's right.
All right, let's see. Can I share the screen now? All right, let me try it like this. Can you see it now?
I can't see it on our shared studio. I can see it only on YouTube.
What do you know about that? Huh. All right. Well, anybody that wanted a professional setup here, I just want to let you know that I thoroughly let you down. We're in the IKEA of live streaming right here. We're all over the place.
We're imitating Love, the way she put her case together.
Hey, okay, quick question. Where's DA Love been?
Letting Hilton take the heat.
See, that's what I would think. I'm thinking like, hey,
She's the one that's the difficult expert, the difficult witness person.
That's my
And
question.
she's MIA from all of this stuff.
Right. So why did you throw her to the wolves like that?
Because she knew she was not supposed to put him on the stand.
Yeah, because he had no business on the stand. Now,
Because I'm not gonna lie, Hilton seems nice, right?
oh, she seems adorable.
Love really doesn't seem nice to me. You know, when I criticize Hilton for things that are going on, if there's intentional misconduct, you know, I'm gonna be critical of that. But I really think she's operating under Love.
No, I agree 100%.
Adrian Love.
Absolutely 100%. And so here's the end of Judge Glanville. And I actually have I have the full, since I don't think the full transcript is available, it's just the timestamps. How about I have that full video. Do you want to go over that?
Yeah.
Okay, let's do this. Since I worked so hard to get this on here, let's do this and I'll bring the full video back in. Can you hear it okay?
No, but I can watch it on YouTube. Just know I'll have a 7-second delay. Well, then I don't think I hear Glanville talking on YouTube.
Oh, no.
YouTube.
Oh, hold on. All right. All right. I think I am proving to everybody that I have no idea what I'm doing. So everybody that wanted
are you using like OBS?
I'm using eCam.
All right, folks.
Now I hear it.
Okay.
But I see me as the picture.
Okay, let me let's give this a second to catch up. So this is the full clip. Yeah, I apologize. I really had this worked out well, and lo and behold, I did not have it worked out too well. All right, so they're telling me they didn't have sound. All right, so I apologize for that, y'all. But we're gonna start with the full video, and then we'll fix it from there. Okay, I understood Glanville, and we'll hear it as well in here. I understood Glanville is saying that, hey, there's these 4 motions that the ones that he shot down, like he was playing Duck Hunt on old school Atari. Those motions have to be heard before they move forward. And to me, it was giving this case is over, as my daughter would say. It's giving that everything's over. But you feel like it is not. So if you don't mind, before we start up, tell me why you feel that way.
I'd like to think that it wouldn't be over. I believe that there's, even before this, I think that there was decent enough grounds for a mistrial. Back to, we're going to bring up Love again, but she really inserted herself as an unsworn witness. She was adding in her own testimony through her questioning to witnesses while they were on the stand, which is why I think it was ridiculous that a week and a half ago, 2 weeks ago, she made...
Yes. I think I know what you're
like,
about to say.
it wasn't even the right type of she filed a motion in limine, which is like not something you expect to see mid-trial. It's usually like pre-trial determinations, requests for certain instructions to be given, or, we don't want this coming in because of that. She filed that after Brian Steele was held in contempt and made this like 2-page complaint about how the judge is being too nice when the defense objects. Which, does anyone in the chat here think that Judge Glanville is too nice towards the defense's objections?
Right. I would love to hear, because I know good and well I would say absolutely, unequivocally no.
So with that being said, I think that there's been a separate reason, even before we entered June, that there should have been grounds for a mistrial, with a prosecutor inserting herself as an unsworn witness. But here we are today. I definitely think there should be a mistrial. I don't see how you can recover from this. I don't see how the trial being paused. The jury's already been gone for a week and a half.
Right. So there's no way
they're going to be gone for...
let's say another month.
How is that not prejudicial?
Right. Let's just
say
another
thinking?
month. Right. Or even 2 weeks. Am I to believe that juror number 7 and juror number 9 and juror number 17 will not...
Don't talk about this at the 4th of July barbecue?
Really?
Oh,
you've been in a couple days.
Why are you broke? Why don't you got any money? Oh, it's late, 4th of July, everything's closed. Let's go to the store and get some more. We're gonna buy some stuff at the store. I don't really got money right now. Why do you not have money? Weren't you making good money? Well, listen, I've been unavailable and only making $25 an hour. I can't tell you why.
No, $25 a day. A day.
A day.
Right. So no. And wait, $25 a day. Are you a juror? And there's off to the races. Am I supposed to believe that? Am I supposed to believe that they're not going to talk about this? Like, if
even
that's
if
what
they
you
try not to.
Right. But even more than that, okay, let's say they don't talk about it. They're going to see it. They've seen the memes. They've seen Woody on memes. Like, oh, that's
Woody's going to show up. Imagine Woody shows up to the big 4th of July party where one of the jurors is at.
That would be so crazy.
He takes an Instagram picture, bro. I'll get you out of jury duty right now. And they take Snapchats.
That is crazy and right, though. But okay, let's be funny. Let's be funny. They go to a 4th of July event, and Woody likes to take pictures. But let's just say, incidentally, I'm juror number 16, and I'm just in the background of the picture. I didn't even know he was there. He was just taking a picture. And that gets posted, and they're like, juror number 16 is at a cookout at
Woody's intimidating the jury
with Woody. Like, come on. There's no way. I don't see that this is going to go any further. I think this is the last time we saw the whole band together. I just don't see it going anywhere. The band broke up. The Fat Boys broke up. It's over.
I think there's more than enough for it to end here. Will it?
Right. Crazier things have happened, but I just can't see a reunion tour starting with this. I just can't. It's over. The band is broke up. Everybody's going.
Well, they made sure they got those decisions on pleas before this happened.
Yeah.
I think that's part of why Glanville was waiting to do what he did today. He held this conference today, knowing that they had that hearing scheduled for the final chance for the other defendants to take a plea or not, or decide if they're going to go to trial.
Got you.
And isn't that like even dirtier? Like, this one's so far messed up, but you're like, let's get the other ones in case.
In my opinion, truthfully, a lot of this could have been resolved if Glanville had just said, Yeah, I was wrong. My bad. And if what you're saying is true, that if he just recused himself, somebody would have stepped in on, let's say, day 90, and they would have kept the train going, then this truly is his fault. If they could have, this could have moved. First of all, I think he made two categorical errors. He should have recused himself, but once they saw that Woody interview was going left, his witness stand testimony was going left, and he allowed the interrogation videos, and they mentioned like, oh yeah, it's just a quick video. It's 17 hours long.
Well, and they decided, because we want to keep the trial moving forward, we're going to watch these today. I think they started to get through part of one and then started the second one today. There would have been less objections to parts of those. And we're going to hold the rest. We're going to have hearings on those. So you like steamrolled into two that should have been filtered through it in some way.
Right. And in my opinion,
it doesn't make sense.
In my opinion, the last, let's say, 2.5 weeks have been total, ever since, let's just say since the ex parte meeting. So has it been about 3 weeks, give or take? The 10th, right? Since then, everything since then has just been crazy. So this 21st day, yeah. So it's been 3 weeks. Everything since then has just been crazy. And in my opinion, it probably all rests on Glanville and the way he handled it, from, again, his 3-hour comfort breaks to not moving this along. Like, no, we're not going to use precious courtroom time to get through, do your homework. That doesn't make sense. And then, of course, now where we are. And I thought it was adorable, and we'll hear it in a second, how he tried to justify the ex parte meeting. Did you pay attention? Did you catch that?
So, guys, when we watch what we're about to watch, know that he's reading something, but his tone of voice, his body language as he's reading case law, you'll notice when he has to read part of the case law that really doesn't support his argument. You will notice it by how he suddenly pauses or winces a little bit. Yeah. You will notice it.
Let's give it a shot. Let's get into this. Let's go.
As you all are made aware of, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts one. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So,
all right, this is kind of interesting. So he was given immunity on Friday. Does that sound right? Did you hear that?
June 7th.
June 7th.
Yes.
Okay. I don't know. I've heard somebody say it sounded like he got immunity on Monday when he was with Kayla Bumpus, but apparently he got immunity.
No, I think that was blurred together because of the inquiry, right? So Steele made this inquiry and mentioned that as part of this inquiry, this immunity deal was in question because he was supposed to testify. So if we walk back, and we'll see some of the stuff if we get into the proffer, but a short recap, infamous Sylvia and then George Chibi, who were both in the courtroom, knew that this immunity deal was already in place because there was a risk of Woody being arrested if he chose to refuse to testify on Friday, June 7th.
On June 7th.
So they were already aware that deal was already made by that Friday.
That makes sense. Okay, let's get it. Let's go.
Answer will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt.
That's Friday. Okay.
Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024.
Okay, that right there is reason why, if you already have a difficult client who's pleading the fifth and getting contempt. By the way, I'm gonna be on a beach drinking drinks with little umbrellas in it for 2.5 weeks. Maybe that's another reason why this client probably should have just cooled his heels rather than came back up on Monday. What do you think?
Or if they knew that there would be this scheduling conflict, better trial management from the judge with the calendar and the
Yeah.
prosecution with what witness they want to call next. It is not impermissible for a judge to say, look, we have to change. Can you find out if this witness can come on this day instead? That's pretty common.
Absolutely.
It's something that if you watch enough trials, you'll see it happen all the time, especially with expert witnesses rather than fact witnesses, right? Because experts are like being flown into, oh, this is, the bioengineering we're going to tell you about. They're coming in, they're not really living in that town. But the judge could have said, look, we want this witness to testify. Are you prepared to have him testify? He was probably, honestly, Glanville was probably told, yeah, he's going to be ready. And the prosecution dropped the ball there.
That's fair.
The prosecutors know who a witness's assigned counsel is at the time. They can communicate with that counsel to make sure everything's in place for them to testify. I would love to know if Melnick informed the prosecution, hey, you plan to call my client on a time where I'm not going to be available. And the prosecution gave the green light to the judge anyway and said, this is who we're calling on Friday.
Yeah.
Knowing that he's going to testify. You know when they called him, it wasn't going to be one day of testimony because we have multiple days of video for him to go through.
Absolutely. So let's get it rolling. Let's go.
The court informed Mr. Melnick that his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Miss Christina Weaver, the court's official court reporter.
So, short of it being, now he insinuates that there was an extenuating circumstance for why they could have an ex parte meeting, because I'm sure we've all become like junior law students. Like I tell people, I'm a pre-K law student. There's certain reasons why you can, and it is right to have an ex parte meeting with one side instead of both sides of the conflict. However, if he didn't know why they were having ex parte meeting, he says the court didn't know what was the parameters of the ex parte meeting. Shouldn't he ask and say, do we need defense in here? Because I don't think it's one of those 2 reasons that I've heard that is normal, or actually 3 reasons that is normal to have an ex parte meeting. So wouldn't you just say, hey, do we need to have defense in here as we're talking? Because it just seemed like, yeah, he was inviting a problem. But go ahead.
Well, I was going to say, on one hand, those exceptions include a comma. They include a condition, provided that it is disclosed promptly, that the court discloses this meeting promptly to the party that wasn't present.
Fact.
Not just that the meeting took place, but also anything material to the case. Those specifics also need to be disclosed, right? So there's conditions. Even when it would be permissible to meet without this, you have to disclose it, and you have to disclose certain things that may have been said during it. But what's the second problem here? On Friday, Hilton asked for a meeting in chambers.
Right.
So Glanville already had all weekend to marinate while he put Woody in the Rice Street jail. He had all weekend to marinate. Then they get together at 9, 10 a.m. and he's the one giving these timestamps. Yes. I don't know if we can trust them. I'm not telling you to trust them. I'm not telling you not to trust them. But if we take them at face value right now from Judge Glanville, he's going to lay it out. At 9:10 a.m., this meeting's taking place, but Copeland isn't even there yet. The defense
Correct.
isn't there at all, ever.
Never.
So you would think that between 9:10 and 10:03, some kind of context would be given why we're all standing here for 45 minutes.
Right.
And what did Woody say on Friday while he was in court? I don't know. Can I talk to my lawyer? The issue was he didn't understand the terms of the deal he was given.
Which is Kayla Bumpus kind of mentioned that, like, and nobody understood it. It seemed like a lot of people were in confusion about that. So that makes sense.
To simplify it down, the reason for the meeting was to discuss this agreement, to discuss this deal and the terms that are attached to it. That was the reason, because they hold him in contempt because of it. Hilton asks for the meeting. Glanville says, no, it's a Friday, whatever. And the first thing Monday morning, they resume, even before Copeland is there. So they weren't afraid for his safety when they put him in the Rice Street jail.
Facts.
They weren't afraid of that.
No.
When you have people digging holes to go and shank someone, according to the same reporter that's in the courtroom, being told not to photograph Copeland being arrested for refusing to testify. But here you're going to hear Glanville make this excuse as to how this ex parte was proper. We don't know why it was had, but I'm going to imply that it could have been for a safety concern for the witness.
It's very possible. Well, let's go. Let's keep going.
This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m.
Okay, they started at what time?
I thought it was 9:10, but maybe I got that wrong. That would make it even shorter.
Yeah. Okay. I'm just wondering.
Oh,
and then Coco's saying the transcript is in the chat.
Who did? Oh.
Coco in the chat. Shout out to Coco. I see Coco in the chats a lot. Coco's awesome.
Okay, let me grab that. Can you drop the link in the chat real quick and I'll have it ready?
Ms. Hilton.
Let me pull it up. I think
the DA's investigators Long and Hamilton. The court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C, 2024.
Okay, to me, right? No, not to me. Judge Glanville is explaining that, hey, we met for almost 2 hours, whether it be with the full cast or partial cast, but it's been 2 hours because literally everybody was sitting in the courtroom waiting. But guess what? When he came in, he didn't tell them, oh, by the way, we've been having, Mai Tais and sushi back here in my back office with everybody just yucking it up. He didn't tell them. And I think that's part of the problem is that instead of coming out and say, hey, we just had an ex parte meeting. It was nothing to worry about. This is what we talked about, which should have been what he did. He just came out and just went to work and never mentioned it.
He could have said, my bad at that moment and said, my bad. I was in a hurry to get the jury on out of here because we already wasted time. It was everything. My clerk's going to put everything, make sure the record, we have the transcripts. We're going to give it all to you. But instead he said, you can get transcripts. We recorded it, so it's fine, but we're not going to give you the transcripts until the appeal. Even though we've got them now, thankfully, because the Supreme Court and the Superior Court had to do what they did.
Right. That's just wild. Okay, let's keep going. I'm trying to get these transcripts so we can We can check it out. Here we go.
Those that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m.
And rightly so.
In asking Mr. Oh, and
Hold
then
on,
Mr.
hit the
Steele
pause.
later that afternoon
about
was
that.
held.
Go ahead.
So if you pull up, Thugger Daily also posted the order to release. Can you pull it up? Because the first line is something that is great. If we're going to get into the transcripts, this is the order to release is juicy too. The first paragraph. I just put it in the guest chat to the tweet, Thugger Daily's tweet.
Okay, hold on, let me grab it. In the guest chat or?
Yeah, in the guest chat.
Where did this chat at? I did not see it, my love. All right, give me a second.
Well, if you go to Thugger Daily, it's his second most recent tweet.
I see it right here.
You'll see the transcripts and then the order. If you pull up the first page of the order, read the first bullet point.
All right, let's pull it in. All right, everybody can see? Can you see okay, friend?
I can't see any of your screen shares, only when they come up on YouTube.
Why is
I have it open myself, though.
All right. So, the state of Georgia.
Because read this bullet point 1.
The order above styled case is currently before the court on its decision to release the entirety of the transcript of the June 10, 2024 ex parte conversation involving state's witness, Mr. Kenneth Copeland, for review by all interested parties. In consideration of the court's release of the transcript in its entirety, CT1, the court takes judicial notice of the following timeline of events. On the morning of June 7th, upon notice from Mr. Copeland's attorney, Mr. Jonathan Melnick, that Mr. Copeland is considering pleading the Fifth Amendment right, his Fifth Amendment right against self-incrimination, the attorneys for the state seek and receive an immunity order, CT2, for Mr. Copeland to ensure his testimony. Wow.
They knew. I mean, we have guessed that they knew, but this is in Glanville's writing,
So this is
memorializing it.
Yeah, this is that Friday morning. So they knew that he was going to plead the Fifth.
Before he went on the stand, they knew.
Before he went on the stand, yes. I wish he put a timestamp. He doesn't have the time on there, which I think.
Well, the next one clarifies that he takes the stand. So that was before he took the stand. So it's there. So Glanville he put the timestamp there. That's not good. That's not good for the prosecution and probably not good for the court because the court probably should have known this also.
Wow. All right, let's see where we're going here. Because all we're doing is going through what Glanville is reading. So is that cool?
Yeah.
Okay, so let's jump over here. Going to, is this the second page? This is the second page.
I have to wait for it to pull up, but I believe you.
What's wrong with my screen share?
I see it now.
Y'all, I got to get better. I'm going to get better. I promise y'all. My goal is to get better at this. I promise. All right. In deciding to release the entirety of the transcript of the ex parte conversation, the court takes judicial notice, and I just read all this. Number one, that Mr. Copeland was goaded into meeting with the court and attorneys for the state ex parte. Man, like, look, you prodded this guy in here. You forced him in here. But let's keep going. That Mr. Copeland asserted that he was going to plead the Fifth Amendment right, his Fifth Amendment right against self-incrimination. That Mr. Copeland was a party as a sworn witness. And I think that's really something that we have to think about. He was already sworn in. So a lot of people, because you heard Brian Steele exacerbate that point. Like he was a sworn witness, sworn witness, sworn witness. If he had not been sworn in, this probably wouldn't even have mattered. But he was already sworn in. So they swore him in and they still allowed him to go, even though they knew he was going to plead the Fifth.
Yep.
Wow.
And Glanville put it in writing.
You think Glanville's just trying to get taken?
It's different for an allegation to be made, right? Even if you want to trust what Brian Steele says in a motion or an argument or a filing at face value, And there's certain reasons that should be considered at face value for certain next steps, right? Like a recusal
sure.
hearing. But that doesn't mean it's factually proven. But when you have Glanville saying it, that's different. That's
Yeah.
different. This is a pretty big deal.
Yeah. That Mr. Copeland was a party as a sworn witness to the defense. I'm sorry. And that the defense had the right to be present at this ex parte conversation, as it was critical stage of trial according to, and we know Scudder, so on and so forth. I'm trying to think what were some of the reasons why they could have an ex parte without them. And I just don't think they had the reasons, but let's keep going. That Mr. Copeland indicated he was not going to testify and that he would sit in jail for 2 years. That's wild, but it does sound like him. It does sound like him. And that the ex parte conversation improperly involved coercion and witness intimidation by the court and the attorneys for the state to force Mr. Copeland to testify. And then down at the bottom, number 6, and that Mr. Copeland admitted that he was the one who killed Donovan Thomas Jr. Okay, so these are just the idea. This is what Mr. Brian Steele is asserting, but we don't know this to be true.
Reading the assertions, right?
We don't know these things to be true. Am I right? Is that fair? Let me make sure y'all can see
Fair
that.
enough. And, remember, Kayla in the motion to quash filed on behalf of Kayla, they don't include that bit about the confession that I'm the one that did it. So.
Yeah, so let's jump back. All right, so what we're reading right here, just so y'all see, is if we go to Twitter, Thug Daily, doing a great job. Here's the transcript, but let's see if I can get it all populated on here.
So we're going to get into the transcript, but there's also, can you pick that screenshot, that little teeny one you're looking at that says June 10th?
Yeah.
Yeah. Now look at that.
On
Look
June
at the
10th,
time.
that was Monday at 10 o'clock in the morning to
10:17 to 10:33.
Right. The ex parte conversation stands in recess while Mr. Copeland has a private conversation with Miss Bumpus. So that's literally only, go ahead.
In court, he had said, I have it down as 10:17 through 11:28.
Yes, he did say it was an hour, because I heard Kayla say, like, I don't remember talking to her for an hour. It was only a few minutes. So this would be a little bit more akin to what she was saying, that it was only a few minutes. And that makes perfect sense.
And that means more time was spent talking there, because the timestamps as they were delivered this morning orally in Glanville shrunk the window down of the amount of time that the judge and prosecution could have been speaking with Woody. Yes. Now this flips that on its head.
Because now they were talking for a good little while. They had a lot to talk about. So let's.
Yep.
All right. Is this the. What is this?
And I can pull up the transcripts with you. It's in reply to his newest tweet. He posted the full document. I can read along on my own screen in case you want to break from some of the reading, because it's 56 pages.
Okay, let's do that. But I want to make sure I have it up. Right here.
So go to his most recent tweet. Yeah, you got it.
Got it. All right. Now we're cooking. Y'all have been praying, because Dear World Christian has been struggle streaming over here. What is up with me? All right, let's get this zoomed in. Where do you want to start?
Okay, so I always like to just check the cover page. So, it's being addressed as the state of Georgia versus the 6 defendants. And then transcript of the ex parte hearing in the chambers of Honorable Ural D. Glanville on June 10th, 2024. So they're going to say appearance of counsel on the second page. That's important too, because it's just Love and Hilton for the state, just Bumpus on behalf of the witness, Kenneth Copeland.
Is there a particular reason why they don't put everybody that was there? Because they said like deputies and sheriffs are there.
Because this is appearance of counsel. They should do this for every transcript. They should make note of what attorneys were present.
I got you. Okay. No, just because I've heard Kayla say that it was like 14 people in the room. And, right here, I got 3 plus Glanville plus Woody, that's only 5. So who are these other
So
people?
they always just make note of the counsel of record. So that
Yeah.
was present. And then at the end, you'll probably see that this was transmitted to a bunch of attorneys as well.
All right, you ready?
Yeah. Who do you want to be? Well, this might be a lot of voices. How about you? I'll be the girls, you be the guys, or do you want to be the...
No, that's cool. I like that. I like that one. All right.
All right.
So court reporter is clearly you.
Okay. Well, they're noting at the top to all the present parties. So ex parte hearing began at 9:10 a.m. Present in the chambers were Judge Glanville, Assistant District Attorney Adrian Love, and Attorney Kayla Bumpus, court reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton. Now, am I missing Hilton being mentioned here?
Yeah, I don't see Hilton here.
So maybe this is at 9:10. Maybe Hilton wasn't there yet. I guess we'll see with who's talking.
Wow,
so
these notes are intense. Like, they don't tell you. Yeah, that's gonna be interesting. She's gonna say, like, "Oh, Hilton came in on Hot Wheels," you know.
Yeah, we might see as we go.
Yeah. All right.
So it's gonna be me talking to myself as the ladies at first. So, court reporter. Okay, I'm ready whenever you are, Miss Love. Thank you. The concern that we wanted to bring to the court's attention as a state was twofold. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces. And we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. The second concern that I have is, and I wanted to bring to the court's attention, in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering. That is their right and their business. As it relates to the testifying, however, I do not believe that criminal exposure is a concern that is, which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 24-507. And on Friday, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and Mr. Shart with me and Simone copied where he said, "This is the communication that I received from Miss Love regarding Mr. Copeland." My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients, which client are you protecting? Whose client, yours or Mr. Steele's and Mr. Shart's? He wrote back and said, quote, "You are going to get him killed. You are making him a target. Fuck you," is what he wrote in the email. So this is the infamous email.
This is the infamous email. Wow.
So this is what Miss we get two little teeny paragraphs. I have other concerns, but then we have all these paragraphs, multiple paragraphs about this concern. So
all right. In the court.
Yeah.
His being whose concern?
Mr. Melnick, if the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned with that testifying will get Mr. Copeland killed, and he is not communicating with us, he's communicating with counsel for defendants, it would seem that he knows a thing or something that we don't know. Additionally, I will let Ms. Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you want to be there for him while he's testifying. Now, we got to pause there because what happened that morning on Friday the morning?
She fired.
This attorney... No. That was Monday.
Oh, it was
on
Monday.
Friday,
I'm sorry. Yeah, you're right.
Melnick was already aware that he was going to plead the fifth.
Correct.
He knew
Yes.
that he knows that you're not supposed to put a witness on the stand who plans to plead the fifth. And look at how Miss Love is twisting this. Do you see the games Miss Love is playing here?
I see exactly what she did. Yes. So, wow. All right, let's get it. Okay, let me get in here. Well, he's on vacation this week.
I understand. That is why he has Miss Bumpus here, and he has said what he has said. And as I was reading the statute, the thing is, and I was reading the statute about this particular situation, and I was reading our rules, our ethics rules of conduct for attorneys, and it is clear that if an attorney, there were two things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Miss Hilton that Mr. Melnick wasn't representing him. And then, rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Shart, and Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on, and that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case and this trial. All that aside, we would like an opportunity for the court to address Mr. Copeland with Mr. Copeland's stand-in counsel present. Miss Bumpus is looking at me like... Miss Bumpus cuts in. She says, I'm listening. Miss Love, with his stand-in counsel present and to allow Miss Bumpus an opportunity to explain to Mr. Copeland everything that I have just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is the statute says, until he purges.
By testifying.
His contempt by testifying.
Yeah, 507 is a little bit different. So, I mean...
So, until the end of this?
He can't be here until the end of the trial. Stop. He said
that is what...
That's basically... I know people say, well, nobody ever said he could be in there for 2 years. But that basically
that's
saying
Glanville saying it. That's the judge saying it.
Right. Okay. Wow.
So that part of the affidavit is true. We have a plus. What do we have? 14 claims. It was like 16 claims in the affidavit. That's a plus 16, 1 yes. For the affidavit claims. So Bumpus says, that is what I said. To the end of the trial is the longest? ? Miss Love. No, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has... convened, has left, that person can stay in until that person purges himself of contempt by testifying. The statute literally says that. Miss Bumpus, well, I'm going to look it up because it was my understanding that it was until the end of trial. Miss Love, nope, here it is, literally the words of the statute. And so...
he could be in there a while. Let's put it that way. Either way.
I just want to be able to give, and then Miss Bumpus says, I just want to be able to give him.
I know. It's kind of the statute says, that you purge, but you can't keep him in there indefinitely. I've got to kind of.
Right. That's all I wanted to know.
The whole thing is that he has the keys to his own freedom. And that freedom is if he just gives his testimony, then he's purged it.
Right. And this is Miss Love now. And, whatever that testimony is, we know what we believe it to be, but, we don't know what it is. We can't talk about it. We don't, we don't know what he's going to say. We have an idea. We know what he's told us. Miss Bumpus says, yeah. Miss Love says, and our concern is that I know the court said essentially, you intimated that Mr. Melnick probably told him essentially you should testify. They can't do anything with your testimony. But what we overheard being said was, now she's saying she overheard this, they are going to hammer you as if we were going to expose Kenneth Copeland to, and Miss Bumpus says, you heard that? Miss Love says, yes, yeah. Mr. Melnick told Mr. Copeland, we're going to hammer him.
Now, to be fair, and I think Miss Bumpus, as an advocate or anybody, has got to tell him he's going to face some pretty significant cross-examination.
Miss Bumpus says, yeah, I think that's what he meant.
I mean, he's got about 10.
Miss Love says, so he meant the defense is going to hammer him? Miss Bumpus says, no, just in general, it's not going to be a, hey, da-da-da-da-da. Miss Love, he knew that. He had already been expressing that.
But, I think that if he's concerned about that, but it's all in the message and packaging in terms of, I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough and sifting cross-examination.
Miss Love says, and the other thing is that, and then Miss Bumpus says, can I just say something in Attorney Melnick's defense in response, just for the record? Miss Love says, yes. Miss Bumpus, the reason that he doesn't want to move forward with representation, what I have been told, if he decides to testify, is that he doesn't feel like he can He doesn't know what was said outside of his presence, so he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. Miss Love. But the thing is that the only thing that he should be concerned about is criminal exposure or the exposure that Kenneth Copeland has criminally. And there is nothing. There's literally nothing. The statute is quite clear that we can do to him about. The only thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you lying. It would have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is, just tell the truth. So, like he says, I didn't go down to the police station.
And I think part of the challenge, Ms. Bumpus, may be that you need to assure him, look, I'm going to be here. And if you think that they are asking you a question, they being the state or the defense is asking you a question that's going to bring out other crimes that he's going to be able to look to you and say, can I have a chance to talk with you?
Miss Love says, that's exactly right. Miss Bumpus, uh-huh, or Miss Love, see, but that's just it. Miss Bumpus says, no, he's not. Miss Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Miss Bumpus says, yeah. Miss Love, there's been an assertion that people are representing that their biggest concern is his best interest, and then they are just not here. And Miss Bumpus is saying she's not in a position to do that. And then Miss Bumpus says, no, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do nothing about that. So Miss Love says, that sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I ain't going to, I'm not going to represent you. I don't even know what to do with that. So Miss Bumpus says, well, he said he does not know what was said. Miss Love says, it doesn't matter what was said. Miss Bumpus says, right. Now, we got to pause there because it does matter.
It does
because
a whole lot.
If your client is being questioned on direct or cross, and you don't know what the contradiction could be, or you don't know what could be incriminating, you can't interject and stand up for your client. So Miss Love is totally off the mark here.
Yeah, this is very weird, but this conversation is fantastic.
Yeah, it is. And where's Miss Hilton?
Yeah, Hilton's still not here.
So, and then Miss Love continues, it doesn't matter. And he didn't ask us. He didn't even inquire, quote, what have you all talked about? He has been talking to Brian Steele and Max Shart. That's it. He's not talking to us. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barges in and gets between Miss Hilton and Mr. Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Miss Bumpus says, well, I think what happened was, and I say this because I previously represented Mr. Copeland previously on his other stuff. So I know this is just what I think happened. I think how Attorney Melnick came involved was his representation of because he took my place. Copeland fired me and hired Melnick. And then this came about. And I think so at the beginning, Melnick was representing him, and then Miss Love says, and his criminal matter that he had. But that's resolved. Miss Bumpus. But when this case started, Melnick called me and told me that he was representing him as a witness in the beginning. I can assert that. Miss Love. Melnick has never in life, Miss Bumpus, this was 2 years ago. Miss Love. Melnick didn't, as a matter of fact, less than 2 years ago when Copeland was sitting in jail for something else he had done. Melnick said, I don't represent him. He told me I don't represent him. And people were in the room. He was on speaker. He told me he didn't represent him. Now he ultimately did come about and represent him. But when we were trying to get, I guess, Miss Bumpus cuts in and says, something, yeah.
What does that, let me stop for a second. What does that have to do with anything? Because sadly,
it makes it worse for Love. If he wasn't
Right.
representing him during the stuff 2 years ago, why should he be expected to know something he wasn't disclosed to by jumping in to represent him now this week?
That's where I'm going with that. And it just seems like you're not doing yourself a solid, ADA Love, But I digress. All right, let's
And
continue.
I'm confused, actually. What page? We're on page 12.
12.
When Miss
Yep.
Love said in the beginning, I want to go back up to that email because I have to get something straight for myself. So stay on page
Okay.
12.
Oh,
I'll scroll
I'll
back
stay
down
here.
there. And then what was this email? He sent an email to Mr. Steele
Mm-hmm.
and
What
Miss
page?
Shart with me. And go to page 4.
Page 4. Okay. And we're gonna be like professionals. So I said like page
No,
4
I
and what
feel
line?
I feel gaslighted. We're going to line 3 on page 4.
Okay, there we go. See?
Well,
Oh,
really,
look.
line 2. I
Line
don't
2.
know if he unintentionally put my name on it, is where you want to get to.
Yep.
But he sent an email to Mr. Steele and Miss Shart with me and Simone Hilton copied. So she was not excluded from this communication. But ever since we read this part, she's been insisting that he's been speaking privately with Mr. Steele and Mr. Shart.
Good
She's
catch.
lying.
Good
She's
catch.
lying through all of this. I've been waiting. I was like, maybe I read it wrong this
No,
whole
you're-
time.
No. Let's read the response. Where he says, okay, yeah, you're going to get. No, he's talking to her like, yeah, like they know.
She leaves out what was said to her initially. Then she says what her response was. She says he sent it to all of us, leaves out his initial email, includes her response, which is self-serving, and then mentions the fuck you thing. Sorry, I
Right.
shouldn't be saying that, F you. But we know Miss Love is very sensitive when she feels personally insulted.
Correct.
So she's like
Wow.
reframing this whole communication scenario as if Melnick is doing something wrong by trying to confer with the defense counsel against the interest of the witness, his client.
Mhm.
And we see her kind of repeat this theme 2 or 3 times through page 12, where he's working with them, he's representing the interests of Mr. Steele and Mr. Shart, not representing his client.
But he really is, and he's told
Honestly,
you that he
like,
is.
she just gaslit this ex parte meeting.
She lit the whole thing on fire.
Like,
All
holy
right.
moly. We can go back to page 12, but I thought that was important to...
No, good catch. That's a great catch.
Where were we on 12?
I think you're on Miss Love at the bottom.
Okay, yeah, something, yeah, because I guess something, yeah. And then Miss Love says, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then Miss Bumpus says, are you talking about recently? Miss Love, so recently Copeland said that Melnick was not his lawyer. Miss Bumpus, right. Miss Love, when Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood in for him on his bond, and then on his subsequent plea, was Melnick. But I don't know whose interests he would be representing when he's not talking to us. She's doing it again.
Yeah.
Guys, start the love gaslighting counter. I think
Yeah.
this is 3 or 4 now that
I'm gonna go with 3.
she's reiterated. Let's do 3.
Let's go with 3.
When he's not talking to us about what we've spoken to Copeland about, he could ask us and we would tell him. Do you guys think that that's trustworthy?
Nah.
So let me keep going. So I don't know why he would withdraw his representation of him. If his interest is Kenneth Copeland, then why would you pull out?
I love it. I'm going to jump in. But real quick, everybody, those people that just jumped into the chat, first of all, I want to thank you all for being a part of the best live chat on the planet. My name is Jason from Dear Will Christian. I have my lovely new best friend now, Kat Not Williams from Kat Not Williams podcast as well. And what we're doing is we're currently going over the transcript of the infamous ex parte meeting between Judge Glanville, ADA, Love, and maybe Hilton, as well as Lil Woody during the the YSL trial. And this is basically what has derailed. Is it fair to say this is the bend in the track that has derailed the train as relates to this YSL case? Would you say that this is it?
Yeah, we're confirming some of the affidavit bits already.
Right.
And it's not surprising to me to see Love speak this way because it's exactly how she speaks orally on the courtroom floor. But this is a pretty important circumstance, right?
For sure.
And you have her stating, well, this is what the statute literally says. And on one hand, Melnick isn't talking to us, but then she's saying that she was included in the email. Like, there's just, it's a lot, guys.
No, I love it. Let me do my part. And by the way, Kat Not Williams, everybody just real quick, Kat in the chat, Go ahead and put Kat in the chat because she's been a beast at reading this because the court didn't say very much. So at least y'all can give her a couple of likes and spam Kat in the chat and let her know we appreciate her. So let me do my part.
Guys, and go on X. You know, if you use X, I think X is a great place. These little
Yeah.
things that we're calling out about the transcript, if you, and we've got the document on our screen, you can either screenshot the screen or grab the actual document from Thugger Daily. Point out these inconsistencies that we're talking about one-on-one. Someone go and make a post on X and say, look, guys, Hilton acts like, or Love, I keep messing them up. Love is acting like Melnick talked to Max Shart and Brian Steele. But she was CC'd on the email.
She was, absolutely.
So she's trying to fan fiction and ex parte communicate, like some type of communication that's one-sided.
I love
right?
it. Absolutely.
She's trying to gaslight. Like, go point out those little details on X because not everybody will sit through a live stream reading of things like this. But those highlights, screenshot them, man, because it's crazy. People don't know that Love has been doing this for 100 days.
Absolutely. And by the way, if you have not, if the moderators could go ahead and drop Kat, not Williams, channel in the chat. I think they've already done it, but if you could just drop it again, please make sure you go check out Kat, not Williams channel, and make sure you give her a like. You know why? Because she used the term fan fiction, and anybody that uses fan fiction, like President Firstborn, who is my daughter, when she does it, they got to be cool and they deserve your like and subscription. So go check out her channel. Let me get this done. Let me do my part. I'm the court, and I'm going to say that doesn't make sense.
Miss Love, at the point where he would face the most peril, if that is his concern, if his concern is, quote, I don't know what they talked about, so I don't know what.
And I thought that Miss Hilton had a list of questions for Mr. Copeland anyway.
Miss Love says she did.
Well, how come you all can't?
He didn't ask to see those. He didn't. And not only that.
Well, can't you all share that with Miss Bumpus?
Well, Miss Hilton has already shared it with Mr. Copeland. That's Mr. Copeland and not an attorney.
Right.
And we certainly will share it, generally speaking. And then Miss Bumpus says, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. But I have talked to his family. So at first, Kenneth was going to testify, but has now decided to take the 5th. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office. So this is... So hold on.
Hey, yeah, hold on. Wait.
Can we pause here? Because this seems recently. They're talking about, in this very email, he went on Saturday to speak with the DA. Am I reading this right?
No. Melnick went Saturday to speak to Kenneth because Kenneth was in jail.
Okay, so Melnick tries to speak with him on Saturday.
Right. So let me...
When is this meeting taking place?
Now
if we go back
I
down to line
understand.
20.
And this is Kayla reading or paraphrasing it. So she says, he went Saturday and tried to talk to him before his flight. So Melnick, went Saturday to try to talk to Kenneth before his flight, Melnick's flight. Okay. So, but I have talked to his family. I think that's Kayla talking because Kayla has mentioned that she knows
and then
Kenneth, she knows
that I'll
his family.
be discharged.
Right. So at first, and so now I think this is back to
but
Melnick.
This is huge.
Yeah.
Either way.
The ADA talked to him.
Kayla and Bumpus and Melnick are both saying here, if he decides to take the 5th, he's going to discharge us because we don't want to be an attorney. Like, we don't want to take part in someone that's going on the stand when we know that he's going to plead the 5th. The prosecution shouldn't be putting him there.
And along with that, we don't know what they've already had conversation. Now this makes sense about what they've had conversation about before. So
yep.
The prosecution and Woody have talked apart from his attorney and counsel. So they're like, I don't know what he's talked to them about. I don't know. Again, that makes sense to, I don't know what he might be perjuring himself. I don't know what he might be inconsistent about or impeaching his testimony because I don't know what
And
he
then
told him.
if he plans to impeach himself anyway, you guys shouldn't be putting him on the stand or perjure, like plead the fifth.
Yeah.
If he plans to invoke after you give him this deal, you shouldn't be putting him on the stand in this manner.
Look, I'm a
So then I
pre-K
think we
law
get to
student, but this makes a lot of sense. Look, I'm
This
okay.
is, I mean, I didn't doubt Kayla's credibility at all.
Mm-mm.
And I didn't really doubt the affidavits, but there were some things in Kayla's claims that she wasn't asserting. So I was like, okay, maybe there's going to be some things from those affidavits that we don't get. And now I think we're at a point where we're getting more. We're getting even more clarification, both from the order to release this transcript and from this bit right here, that everybody in this ex parte meeting was well aware he was going to, that this issue was in place already. There were
Correct.
meetings. Counsel was bouncing in and out, trying to catch up with what was going on.
Absolutely.
I find it highly unlikely that the court didn't know that this circumstance existed on Friday, even though he turned down the meeting and said, I don't want to meet on a Friday afternoon. And the prosecution absolutely knew, unequivocally knew.
That they did.
All
right.
So I think I was on line 18.
I think you're on 18, yeah.
So this isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's going to sign this. Miss Love says, and that's just it. It's like you never know what somebody's going to ask. And if he's concerned about putting him in legal jeopardy, then it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Miss Bumpus, you can't switch now that he gets called? Miss Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. Hold on. We got to pause right here.
Yeah.
Is it in the defendant's best interest or is it in the interest of due process?
Right. That's the thing. Like, this is a false dichotomy. It's not the witness's best interest versus the defense's best interest. Is what is the right thing to do? Because if you put somebody, I mean, just look at what happened. Look at what has happened by putting him on the stand, and you knew he was going to plead the fifth. Look at what happened. Because again, Kayla literally says, couldn't you have switched it up? So that, to me, that makes sense. Like we asked before, can you get like a pinch hitter in? But no, you went with him, and now look what you've gotten.
It's crazy to me. Like,
I truly believe like this sentence right here is going to haunt them for a long time. Sentence 4 on the top of page 15. You can't switch how he gets called. Like, and it's a question. Like, you can't just switch it up? Okay. All right. Somebody said something, this is something I want you to think about as well. Carrie said it. There it is right here. I would bet that more of these meetings happen without defense knowing. They seem
I absolutely agree.
Super comfortable. Like, this is a path well worn. This is not your first time at this rodeo at all.
And we're seeing Hilton referred to in the third person. She's not here yet. And now this story that possibly she may have been crying, right? There was like a story that possibly she was crying
on Friday.
And it could be because if she walks halfway in on this meeting after Miss Love has, I don't even know what you would call what Miss Love is doing here. But it's not balanced. It's not really attached to reality. In the same breath that she's saying that this isn't in Copeland's interest, she's acting like she's trying to act in Copeland's interest.
Right. She's definitely trying to say, hey, I'm looking out for his best interest.
But it's her interest to get this testimony how she wants it.
It is, yeah. It's definitely a wolf saying, I'm looking out for the best interest of the sheep.
Oh my God, wait. We're going to love line 7. My eyes just darted forward about this, jumping from line 4. Are you ready for it?
Okay,
Let
go
me
ahead.
read. So Ms. Bumpus says, you can't switch how he gets called? Miss Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch and how he gets called, what does that have to do with anything? Ms. Bumpus, I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. So they're saying the same thing we talked about before we pulled up these transcripts. Just call a different witness. You could have called a different witness on Friday.
You could have called a different
And then Miss Love says, that is not what he said in that email to you, and that is not what he relayed to the court. And his concerns have nothing to do with
He was very much
And then Kayla says, I tried to go back and watch as much as I could.
Telling me what he was, that he was going on vacation. And I said, well, you inserted yourself in this. I said, really? You need to come on Monday.
So Miss
I'm
Love
sorry.
says,
That is,
yeah, go ahead.
I'm sorry. That's just, I'm sorry. Being
They're
able,
playing it both ways.
right. Like this man, you're saying the man is not a part of Woody's life, but he needs to come up, be a part of Woody's life. No, you can't have them both. You cannot. And I'm sorry, if the man already has a vacation plan, and apparently he told you well in advance. So it wasn't just like he told you on Friday, hey, by the way, I ain't gonna be here Monday. He didn't say that. It sounded like he had told them well in advance. No, just because y'all don't know what you're doing, which does seem to be the case. No, you can't do that to him. I'm sorry.
And it
I don't
also
know
sounds like
Jonathan Melnick
Woody. Go
Go
ahead.
ahead. I was saying, I
I
don't
was
know
saying, it sounds
Jonathan
like
Melnick,
Woody.
so I'm not trying to defend him. But that's just it. We keep talking over each other. Go.
I was just saying, it sounds like Woody, they mentioned it in this transcript that Woody was like, well, why do I need him too? So we know that he fired Miss Bumpus. He wanted to discharge her. He had the discharge papers ready. And it seems like he held the same kind of attitude about Melnick. Like, why do I need him here? Speaking about on Friday. And they kept bringing him in because they probably wanted to make sure that no one could say that they did this without someone representing Woody's interest.
And look what we
Like,
have
I can't
here.
really find an explanation of why they're playing both sides so hard here.
All right, Miss Love.
So he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify.
I think you are in until it's done. I mean, you know.
Who, me?
No, you gotta say that. You gotta say that like you mean it. You gotta say that with some. You are now being told that you're the stand-in, the substitute teacher is now going to be the teacher.
Flight to catch.
Yeah,
and I might be stuck here.
right,
and
right.
The way Love and Glanville are saying this, it's like they don't even understand that she's only here for the contempt issue. I think when they say these two lines, the lines between 21 and 24 between Miss Love and the court,
Yes.
I think when they're saying here, I think you're in here till it's done, they mean the trial, because that's the word they used earlier, was to describe the length of the trial until it's done.
Right.
And then Glanville almost catches himself, and Kayla catches it like, who, me? Being stuck here until the end of the trial? You're saying I'm his counsel all the time now?
Yeah, I mean,
Like,
that's just, if he testifies, you've got to kind of, I hate that. I hate it because if he had said, like, once he purges himself of his contempt, then you're free to go, or he had the chance
to get it right there, and he
could
did
have right there. Okay, go ahead.
And Miss Love butts in to help with her assist, saying, and frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter.
Not necessarily. Anybody who's facing contempt can get counsel. I mean, not anybody, but.
Bumpus says, I can't stay. How long is this going to take, Miss Love? It might take some days, Miss Bumpus. Miss Love. And see, that's just it. And I think Miss Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her, and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interests of Kenneth Copeland. And that has nothing to do with Kenneth Copeland's exposure if he testifies. Just to answer the question about what he is exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court order. That is saying even if he got on the stand and said,
he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, yeah, there's a lot of stuff they could ask me about.
Right.
That is not known to a lot of people. And that, he could also invoke his Fifth Amendment with the evidence of counsel. Well, I'm sorry, with the advice of counsel, if that was some other particular crime. But
even that, we wouldn't even
that, he'll still have to testify.
Literally, right. The saw lays.
Yeah, I
The
mean,
law says? Is that a typo?
yeah. I was wondering
I
what
think
that
that's supposed
was.
to be the law says.
Right, the S and the L have been confused. Yeah, I mean, anything he testifies to.
We do this. And then Miss Bumpus says, okay, and then about the delay or stall. Isn't it true or is it not true that he had a leave filed since December? Call it out, Kayla. There you go, guys.
Okay, so
There
he
you
has
go.
been, so that means that Melnick told you back in December. So this is June. So we're talking better than 6 months ago that he wasn't going to be here.
This is crazy. We got, what page are we on?
This
What
is
page is this, guys?
That's page 17.
We got to 17 pages of Miss Love acting like, oh, we have no idea. He just injected himself and then wanted to bail.
Right. But listen what she says next. So look at what she says on the top of page 18,
Okay.
line 2. Look at that.
We have nothing to do with any of that. He injected himself into this.
But whether he injected himself or
Oh
not
my
is almost a
God.
moot point. The play as if you didn't know that he was involved in it seems to be, you seem to have trashed that. It seems to be like, well, you really were involved in this. All right, let's
But
keep
it's
this going.
it still
Okay.
makes no difference on court management. They could have called a different witness. They could have had better trial organization, and
Yeah,
they chose not
management.
to.
Absolutely.
Woody took the stand on what, day 89 or something, day 87,
I want to say 85, but I mean, because it was almost
something
2
like
weeks
that.
of chicanery.
They could have gone through all these recordings, waiting for Melnick to be back in town.
Right. There we go. Could have did that.
So
And then-
boom, problem done.
Right. But let's keep going. The court. That when you get involved, I don't know you have a leave.
Right,
I don't know you have a leave. But he told you had a leave since December. Kayla just said it.
Do you see how the court and Love are talking over each other, trying to argue and defend their own garbage? They're both trying to rabble through an excuse right here. That's why the transcription can't catch it.
Yeah.
They're both arguing in the same direction, and Kayla every time is just like, well, wait, what do you mean? Is it true or not true, that blank? And then
That
they
is
both
correct.
try to answer. They both try to scramble for an answer.
That is correct. All right. So, and that's Love right there. Line 11.
Okay, thanks. Right. And then Bumpus says, okay, Miss Love. And he did not.
So he didn't have one. Didn't have
Miss
one
Love.
what?
He has like come and go attorneys.
Right.
Miss Love says, Mr. Copeland's been a witness and a name on this witness list since.
Okay. So since he said, well, I represent him, I'm like, okay, well, you don't have a leave that's filed in our court, in our case.
Okay. And then Miss Love says, so wait, you going to say something?
No, I'm just like, wait. Are you saying, so is, I'm a former classroom teacher, if anybody doesn't know. So I taught elementary school. So I'm looking at Judge Glanville as like the principal of the school. And ADA Love is like the grade level chair of, second grade. So I would report to the principal and say, hey, I'm going to be gone in June. I'm taking a vacation, taking a 2-week vacation with my family, and I filed it. I already know I have a substitute teacher coming in to cover for my class. And then I would go to my grade level chair and tell her, hey, I've already filed this with Mr. Bumblebee. Mr. Bumblebee said it's good to go. I'll be gone for 14 days. I got Miss Caterpillar coming to watch my class, and I'll have everything in place. Come ready. But I'm letting y'all know ahead of time. I don't have to tell my grade level chair, but it's the right thing and appropriate thing to do. As long as my principal knows and the district knows that I'm not going to be there, we're good to go. But here, Melnick is kind of saying, not Melnick, I apologize. Glanville is kind of making it sound like he didn't know that he was going to be on vacation, but he said that he was. And if you did it back in December, that's a guarantee. You guarantee to get the best substitute. You guarantee to have everything in place, because that's almost 6 months ago. It wasn't like 6 days ago.
When Kayla went up to the podium, Glanville said something.
I don't remember what he said. Go ahead.
Did he not say, I don't think I have appearances for either one of you in this case? Meaning he didn't have a notice of appearance filed with the court for Kayla Bumpus or for Jonathan Melnick. Didn't he say that? And he could have been wrong when he said that. But the point is he said it, so his perception was he doesn't remember a notice of appearance. But here in this ex parte meeting on that Monday, he's acting like he was locked in and he should have filed a notice with Judge Glanville that he had days where he couldn't be present, even though when someone's on a witness list, that doesn't even mean that they're necessarily going to be called to testify. They're listed so that the opposite side can prepare and people can start planning and, you know, make opposition. Hey, we want to oppose this witness because, or we can get ready to bring in a witness for a rebuttal to that witness, whatever the case may be. Just because you're on a witness list doesn't mean you need to be available for the length of a trial, which in this case would mean every person on that witness list needs to be available at any time for 2 years. Like, it's not practical. So for the court to be acting this way in this ex parte meeting, for Glanville to say, well, if you don't file a leave for something.
But he did. That's the problem. He did file a leave. So if
December.
I come back from if I come back, you know, to my classroom and they burn the whole school down because my kids are wild, you can't say, well, Whitaker, you didn't tell me that you're going to be gone. Like, no, I filed it with Mr. Bumblebee. So I think this is problematic. Okay, let's keep going.
Yeah. Okay. So he did this himself. Okay. And Miss Bumpus says, okay. And then Miss Love says, so he did this to himself and he did it to you. But we have to, you know, that is just where it is. And I don't know that. That's just where we are. Miss Bumpus says, so Judge, you're going to make me stay if he chooses to testify?
I am, because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point.
Miss Bumpus says, Your Honor, I don't have a problem with that. I'm not ready. Miss Love says, there's
nothing for you to be ready about. Ooh, oh my God.
All this time, this is supposed to be in Woody's best interest, and now you're saying, just stand there so we can proceed, even if you're not ready to represent him. This is so backwards.
You're just a body here. That's all it is. Let's keep going. I mean, let me start over again. There's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here is the questions the state is going to ask you. All right. Is there anything else that could hurt you that they might ask you about? And as long as you have a knowledge of that, then I think that you are fine, because the states are only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they are probably going to kind of.
And Ms. Bumpus says, what about if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble? Because I was only for Monday. That's what I was told. I was given specific. And then Ms. Love says, if Copeland said, I don't know what Mr. Copeland wants. It's his choice. Bumpus, can't he say he doesn't want Melnick? Love, he can say whatever he wants. It's his choice. This is so funny in hindsight. Miss Bumpus, but the judge is saying, Miss Love, I don't think he can be forced to have representation if he doesn't want, need, or say he wants it. Because we have offered. We have done everything to clear him of judicial exposure. There's nothing he can say. He could lie. That puts him in,
Wow. Hold on. I feel like I lost place. Okay, sorry. Peril.
And then Ms. Love says, peril. But, he can't talk about a crime that we could then prosecute him for.
That is involving this or some other place.
Right. And then Bumpus says, I understand that, but, Miss Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about, because he is literally shielded. Bumpus, I would have to agree with you that I don't think that that's the concern. Isn't that what you said? Miss Love, well, the court said that. Miss Bumpus, no, I'm saying with Mr. Copeland not testifying. You said you don't think that his concern is criminal exposure, or you do think that is what he's worried about.
Do you think that he's fearful of testifying for other reasons, like his own personal safety?
And Bumpus says, right. And then Love says, that is what Mr. Melnick said to me in an email I can pull up. He said, Bumpus says, but you don't believe that. Uh-huh.
Wait, Mr. Melnick emailed her?
Now I'm in communication.
Right,
not
now you're in
just
communication with him.
I I can pull it up when I need it. Even though I didn't want to read it in full earlier, I wanted to only read the part where he cursed at me.
Right. But all of a sudden I do have this. Actually, I got it on my phone real quick. Let me pull this up and read it to you. Okay,
Bing,
keep
bing.
going.
But you don't believe that, Miss Love. You're going to get him killed. And that's in quotes. That's what he said. We ain't going to kill him. Bumpus. See, I don't know anything about that email. Miss Love. We ain't going to kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do?
That is a collateral second and third order effect. Let's pray that doesn't happen. But in light of what happened,
shout out to Glanville for calling that out, because Glanville did just call out Miss Love's BS there.
Yeah.
Miss Love is playing dumb and saying, we're literally not going to be the ones that kill Kenneth Copeland, so why is there a concern? That's why we don't believe Melnick's concern. And Glanville calls out, well, yeah, but what you're putting him on the stand to do indirectly could cause a concern. So thank God Glanville's not that complicit.
Right. Good gracious. And in light of what happened this past weekend with Tay, this is really problematic to hear them just kind of flippantly say, oh, listen to what she's saying. We're not going to we're not going to do it.
Well, and then she wanted
Excuse me?
to search for a word that sounded like it had gravity. She wanted to search for, because the way that's written in the transcript, the peril part, it's like she's going, that puts him in, like she's shopping for a word. And Judge Glanville comes in with the assist and says, peril. And he's
peril,
like, peril,
right?
yeah, that's the word.
Yeah.
Like, you just solved the puzzle.
Oh my
So
gosh,
she's searching
okay.
for this weird, and if you're looking for the word, that means you don't really see peril being a reality. Otherwise, you'd be
That's
able to
correct.
think of the word that describes what you're thinking of.
Right. And
But
let's
you
keep in
waited
mind
for
what
the
you're doing.
gravest word. Yep.
Right. Let's keep in mind what we're actually talking about. Like, this is not, again, a bake sale or, the community garage sale. We're talking about someone potentially testifying against, again, a violent street gang, as you have proposed, as you position them. Why would you not think that this would be a real issue? But by the way, they never knew about this potential. Now, Woody has not said that he was he's been threatened or he is in danger. So still this ex parte meeting is still out of pocket because they don't know that. They've kind of mustered this up.
Well, and they
since
say
then.
here, they call it out that Miss Love doesn't believe it. So you're calling
there's that too. Yeah.
It's clearly about securing his testimony. And we're going to find out, I'm sure, because I trust the affidavit at this point. I didn't really doubt it, but whatever. That's my own personal bias. But now this is reinforcing where I stood on the affidavits before we got this transcript. But with this, we're seeing her say, well, I don't believe that there was really, a risk. We're not going to kill him. He's fine. Why should there be an issue? Why do we need to? His life isn't at risk enough to stop him from testifying.
Correct, man.
So it can't be used as an excuse to hold this ex parte meeting because they're not even considering, they don't believe that there's a risk of him testifying. So that can't be the reason for this meeting. It's all BS. And Glanville stood down on it, 10 toes down on it today, acting like safety was still a possibility.
All right, where your love?
I think I was at 17, right? So,
sounds about right, yes.
Obviously he
has to give testimony, though. That's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent, I should say.
So we would like, with the court's permission, they haven't brought him over, and he was supposed to be the first one up. So I guess they went to get him. They might be over here with him now.
Is he here now?
I don't know.
Judge Glanville exits chambers 9:33 a.m.
Miss Love says, we would like to just go into another courtroom and talk to him, give you a chance to talk to him, and then give you an opportunity to explain to him.
We're off the record. Brief recess.
Okay, so this is where I think Kayla and Copeland are allowed to speak in chambers together.
Only a minute. Well, there's only a minute. And I don't see Copeland. Okay, keep going.
Unless they're just... Yeah, let's see.
Because I don't see Copeland.
Weird.
You see Judge Glanville right here. It says, brief
recess.
Yeah. A minute long
So
recess.
Glanville and
then...
Chamberlain enter chambers. And is Chamberlain one of the deputies, or is that one of the DA investigators?
I think it's a DA investigator, but I'm not 100% certain.
Did I write it down? Okay, wait. I wrote the DA investigators were Long and Hamilton. So that must be a deputy then, because I didn't write down the deputy names, but I did write down the DA investigators. So it seems like Glanville and a deputy enter chambers at 9:34. And then Miss Love says, Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. So wait, what?
Why is she downstairs?
Why is she communicating?
So she was in the
with
building.
him?
She was actually in the building.
Why is she communicating? Is she communicating with Copeland?
Okay, read that again. Miss Hilton has been communicating with him. So wait, let's go back to...
I'd like to give you the opportunity to explain to him. So Miss Love is telling Kayla, go talk to Kenneth Copeland. Go talk to Woody. And then we have Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. Where is Mr. Copeland? Look at the next line. Why is Hilton talking to Copeland?
Where's Mr. Copeland? Oh, Mr. Chamberlain. They took him upstairs to the tank in 9. Okay, can we bring him out your chambers is being used. I mean, your courtroom is being used. Let's bring him in here, Chamberlain. All right, so let me see if I can get that done. Let's bring him in here, okay? Thank you. We'll just bring him in here. I think at this point, you clearly need to let the other team know what you're doing, but that's beside the point.
And why is Hilton talking to Kenneth Copeland?
That is crazy. Why?
So it's like you're trying to get Kayla to agree that he needs to testify, and you leave this beginning before you bring Copeland in with we need to tell him. I mean, you need to tell him. And then we find out that Hilton's also talking to Copeland at the same time while they're arguing that Melnick, we're not trying to be mean to you, Bumpus, but Melnick isn't looking out for Woody's best interest. Well, is Miss Hilton doing that in her own conversations with Copeland by herself right now? Or we're trying to goad you into nudging your client to doing what we want? This is not good. This is not good.
This is less than good. Okay, real quick, let me just go. What's the time? Mm-hmm. So we're at 9:34. These are some slow talking conversations. Because that means there's 26 minutes between here and this next sentence right here, which is at 10:03. So actually 29 minutes of slow talk. Okay, so they're just recessing. Okay, maybe they're just recessing. Okay, so recess.
I do think that they're probably recessing because they do mention,
okay,
Kayla was in the hall. They're probably trying to figure out where to let Kayla and Copeland talk to each other and get Copeland upstairs.
Yes. Which
can probably take a surprising amount of time. And then we have Mr. Copeland enters chambers at 10:03. Also present were Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Kayla Bumpus, Court Reporter Christina Weaver, Investigators Antonio Long and Rashid Hamilton, and Deputy Houston, Deputy McPherson, Sergeant Brown, and Sergeant Hall with the Fulton County Sheriff's Department. So Chamberlain might just be a different deputy that wasn't standing in for this part. Maybe he came upstairs to let them know Copeland was here. So he might be a 5th deputy that wasn't one of the 4 present.
There's a lot of them. Okay, yeah. Mr. Copeland, can you let him know I got a hearing problem?
He started right away. That's so funny.
Woody is undefeated.
Oh my
Woody
God.
is undefeated.
Hold on, that is hilarious. Oh my gosh, is this real?
So where was Hilton? That's what I'm not understanding. Where's Hilton been?
Present now. Maybe she's not.
Remember, she's in communication. She's been in communication with Woody.
Yeah, I mean, that's problematic.
And ADA Love knew it. So how in the world does she know that she's been in communication with Woody? She's been in this meeting with him. This is getting weird. Just
I don't know.
This whole thing.
And I wonder, I'm just going to say, we don't see her talking on the first page at all. What do you make of that she's not saying anything as she walks in? They're not even saying, like, welcome, Miss Hilton. They're not recording any of this.
Yeah.
Do you think that's significant, that they just roll right around Hilton?
I don't know what to do. Go ahead, Bumpy, so I can It's like, because I get to play Woody. That makes me, I love this. I love this part.
Yeah,
All right,
this
let's
is good.
go.
That's a great first line for him too. So then Miss Bumpus says, okay, he said he is hard of hearing.
That makes two of us. I've got a hearing aid that's coming in on the 27th of January. Of June. So I'll try and talk loud. Is that okay if yeah, I can read lips. Okay, good. Mr. Copeland, good morning. Good morning. All right. I just wanted to bring you over and let you talk with Miss Bumpus and see if there is anything that you need to ask of our counsel, or rather of your counsel, or Miss Hilton, or the state, or the court before we bring out this morning, because we would like to hear your testimony, and that is a kind of where we are at this point in time. So is there anything you want to ask? But you're not letting him talk with his counsel apart from you. It still doesn't seem like there's not a disconnect between, we're not all one happy team. You know what I mean? Like,
Hold on, read his next
I'm
thing.
trying not to look at it yet. Okay, here we go. Never mind. Well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. The man is telling you that he's lying. The man is telling you that he's lying. Oh my gosh. Okay, well, the only thing you can give is truthful testimony. Whatever you know is whatever you know. That's it. Oh,
and we have Miss Hilton.
Miss Hilton is into the building. Let me give her a little shout out. I need to find a sound effect for Miss Hilton. It's into the building. I don't know if my sound effect is working. Okay, go ahead. It's too low.
And what we'll say, and Mr. Copeland and I, we have talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week, but if any of your concerns deal with being locked up for anything, you can't, there's nothing that can happen. The feds, and then Bumpus says, well, that's not, and then Miss Hilton says, it is true.
Hilton comes in hot as a firecracker. Let's go.
Heck yeah, she's cutting Kayla off right there and says, it is true. Miss Bumpus says, no, and I said that that's not his concern. Miss Hilton, if his concern is safety, we need to know that. That's not expressed. So we don't know what the concern is so that we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had conversations before. This is not looking good. This is the second time she's talking about having conversations.
Before.
I want to know, guys, the first thing, if we get eyes on any filings from the defense attorneys after this transcript comes out, we're going to see this challenge. I'm sure they're going to say, we don't know about all of these meetings. Can you please give us a list of all meetings that anyone from the attorney's office has had with this witness immediately? Because what are these conversations, plural? So Hilton goes on and says, I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations, done. The state statutes of limitations, done. So there's nothing. I researched it this weekend again. Both those statute of limitations for what you and I talked about, which is in 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide. Immune, period. So if that is the concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide is 4 years. It would have been 2019. Finished. Next concern. What may happen in the street? I feel like Hilton's reading an essay here.
It does feel like that. Where are you getting this from?
Concern. Argument 2. What may happen in the street? You know what we have talked about, what we can do as far as living and all of that. We've had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I've got to tell that to you, what I've got to say to you. We do not want you sitting in DeKalb or whenever they got to you because of this.
It's DeKalb.
It's
DeKalb.
Yeah, sorry, DeKalb. But hold on, so this seems like Woody may have said, I don't want to go to DeKalb. I don't want to be held in DeKalb.
Right. DeKalb. I'm wondering whether they're not going to Fulton County Jail. I don't know. I don't know the ins and outs of. I try to stay out of the jail system altogether. This is as much as I want to
Right, but
deal
it
with
seems
jails.
like here Hilton is like mirror matching a concern that Woody may have raised to her during one of these conversations, right? She's not just
That is correct.
volunteering this out of thin air. It
That is
seems
correct.
like he said, "Well, I don't want to go sit in DeKalb. Where are you going to send me?" Yeah, I'll go there. So for whatever reason, he doesn't want to go there. And then Hilton says, "I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Miss Bumpus, I'm here, but we do not want you in custody. You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it. Literally. Judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court." So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Miss Bumpus, as I told you, that is what this order says.
And that is direct or cross-examination.
And that is direct or cross-examination.
So if you are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Wow. I just want to go back. Like, she literally put out there, like, you could confess to a crime of murder and we wouldn't prosecute you.
As long as we have no other evidence.
Right. Okay. I got family members watching this trial, and I don't want my nephew and them to hear the things that I may be involved in and think it's okay. Okay.
But I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I done lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's a better conversation you can have with your nephews in person. But they shouldn't have to come to the DeKalb County Jail because you are being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. He's not supposed to talk about his testimony while he's still under whatever.
Yeah.
Hilton, get it together. You can have that conversation with anybody. That's not what you're supposed to do. This is horrible.
But y'all did this
intentionally.
Oh, I'm sorry.
No, go ahead.
But y'all did this intentionally.
No, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Didn't she just say we didn't get to talk on Friday?
Yeah, I'm sorry. This is, the amount of motions that are going to be filed because of this is going to be staggering. It's going to be staggering because this is bad. Because they're literally just having a conversation. They're just chit-chatting with this guy. Are they hanging out at Starbucks with him? What's going on?
And
right.
they're going to ask. We're going to find out that these conversations weren't disclosed.
Oh, yeah. You knew my child's birthday was next week. That's right. She did ask about that. She asked how old your child was.
I want to go back and actually watch when he got back on the stand, if you can see the scorn. Because this is probably the explanation, is he really was held by Monday, and when he testified during that week, his weekend for his child's birthday had been missed. So he had no problem toying with Hilton that whole week. At all.
Yes.
But she says, but what did I tell you? When we met with each other, I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth. And that is exactly what you did on the stand.
But what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday. But
I told you we were giving you immunity. So were they telling him already Tuesday, Wednesday? This is the proof again right here. They already knew he was going to plead the fifth if they were talking to him on Tuesday, Wednesday, Thursday, before June 7th, before June 10th. They already knew that he was going to plead the fifth, and he told them repeatedly. This is not good.
No, this is not the good look that you want, Fulton County DA. But I told you you already said that, I'm sorry, that I was pleading the fifth.
No, you did not.
I told you every day I was pleading the fifth.
No, you did not. And we told you.
I told you my concern.
And we said we could give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity.
So I didn't tell you I lied on them to get myself out of the situation.
You said you were a liar. That's what you said. You said that you're a liar. And Kayla says, was this recorded? Hilton, no. Kayla, and did he ever say that Melnick was his attorney? Hilton, no. This week, when we first met you in the car on Friday, she met Kayla? No, this is Copeland. Why is she meeting? Okay, guys, so Miss Hilton says this week.
No, this week.
When we first met you, Copeland, in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him.
Okay. Is Woody just lying to cause confusion?
I don't know, because we've had... Now, we have a question of if there was an appearance record from Judge Glanville, and we can go look at the documents and see if there was an appearance filed in by Melnick at any point. Mm-hmm. We know Kayla wouldn't have filed one. There's no reason she would have filed one, period. But we can see if that was filed in. But we've already seen a contradiction before Copeland was even brought up.
Oh,
where
tons of them.
Love was insistent that he was his attorney, and then he wasn't, and she switched at the time and place where she thought that. If someone's actually entered as counsel of record, the state can look at that information. This was a huge issue that just came up in the Courtney Clenny case, because the state, when her parents were arrested for possibly looking in a laptop they shouldn't have been looking in, the prosecutors went and looked at communications between the attorneys and the parents, but the attorneys were also representing the parents, which meant that was protected by attorney-client privilege. A judge had to rule that the state violated attorney-client privilege there, because they could have just gone and seen who they were representing, and even asked, "Hey, is this, we're looking into this. Or is this your capacity, of counsel for these people? Before we look through these messages, we're not supposed to look through." So the state can't play dumb here. The state can't claim on one hand, oh, he is your attorney, or he does have an attorney, and then play dumb when it benefits them. So either way, it doesn't really matter that Copeland is lying about this, if he is lying about it.
Wow.
Because they could still probe to find out.
Absolutely. All right. I forgot where we are.
I think on line 1 on 29.
All right. Let's see. Am I on the right page? Okay. Mr. Copeland. No, I never said he's not my attorney. I said I haven't talked to him.
You said he's not your attorney. You haven't talked to him. Then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone.
You didn't make me feel like I needed him.
But if you needed him, we would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is, but you've just got to answer the questions. We believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what I said before, and I know what you said later. I know what you said before, and I don't know what you're going to say on the stand, because you and I never went into full details about any of it. But what I don't want is you to be sitting here in custody.
You did it.
I did not do it. You did it by pleading the fifth.
You told me before you went to the judge with whatever the thing called you went to him with, you told me that I can't, when I'm asked a question, I can say, I don't recall, or I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity. And I was like, it was something. And then Thursday or Friday came. And then y'all go tell me, oh, we went to the judge with this, so you got to testify. If you don't testify, the judge gonna lock you up.
Right. But that was based upon what you...
But I told y'all that.
No, you didn't.
You said why would I plead the fifth for something I didn't do? And I said, you don't know what happened.
And I said, I don't know what happened. Only you know and them know, I said. But you never said, I am pleading the fifth. You said, what if I do this? What if I do this? What if I do this?
Wow. I told you, I said, I'm going to plead you said, why would you plead the fifth to something that you know you didn't do?
So Kayla says, so if you didn't have immunity prior to, is that what you're saying? That you feel like he didn't have immunity prior to?
Copeland, immunity came Friday, right when I went to jail.
Hilton says, the immunity only came after Mr. Melnick. Kayla, hold on.
Hold on.
Hilton,
Yeah.
the immunity came after Mr. Melnick sent us an email saying, my client is pleading the fifth. That was on Thursday evening at 6 p.m. Kayla says, okay. Miss Hilton says, so after that was an emphatic, he is pleading the fifth. Kayla, uh-huh. Hilton, we came and we got this signed. Kayla, uh-huh. Hilton, and then Friday morning came. Kayla, okay. Hilton, so between Friday evening, Mr. Melnick reached out to us, said he represents him, he's pleading the fifth. Bumpus says, okay, and when was the last time you talked to him before Melnick got involved? Hilton, we talked to him earlier that day on Thursday. Kayla, okay, and then how did, speaks inaudibly to Mr. Copeland.
He called me.
Bumpus says, okay, I was just trying to get a timeline. Hilton says, sure, right. So we've been talking since last Friday. Thursday? Okay. So I met with Mr. Copeland. Right? Did she just try to wrap that up?
Yes, she did.
So I met with Mr. Copeland last Friday, I think out in the neighborhood. What? Then he came on Tuesday for court. We talked briefly on Tuesday, and then on Wednesday he came.
Thursday.
And then Hilton says, no, I think he only came 2 days, so it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got the immunity motion.
So that would have been Friday
morning. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came, and then we had court. And Kayla says, so you're pretty much saying you didn't ask for this.
I didn't.
Hilton, but we gave it. He doesn't have to ask for it. Kayla says, I know. I mean, he's just saying. Miss Hilton, right. He doesn't have to ask for it. But to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it. Kayla, so if he wouldn't have had this, I'm just saying this so he can understand it. I'm walking him through. Hilton, uh-huh. Kayla, would he still have had to testify? Or would he have been able to plead the fifth? That's what he's saying. Hilton, if he did not have immunity? Kayla, yes. Hilton, yes, he could plead the fifth.
That's what I'm...
Kayla, that's what he's trying to say. He's trying to say he didn't ask for this.
Okay, so stop for a second, because I think...
Yeah, this is big.
I'm actually understanding Woody. I actually understand it.
They tried to play him, and he's not stupid enough to be played. He knew what they were doing.
So he wanted to plead the fifth and be done with it. To say, I plead the fifth and walk out the door and be good. They gave him immunity and forced him to testify, and he didn't want to testify, is what he's saying. He's like, no, I wanted to plead the fifth so I can go on and be done and say I can't testify. But they said, no, we're going to compel you to testify by giving you immunity, and you're not going to be charged for anything that you say. And he's like, I didn't want to do that. And that's what that's what we've been watching on the stand and even in the interrogation, is a man who did not ever want the immunity in the first place.
Right, and it's an agreement that was one-sided. It was actually asked for outside of his presence. There was no ask. There was a telling he's going to plead the fifth. There was a telling. He was told, or Hilton was told, he's going to plead the fifth. And we're just going to go get this order and have Glanville go and sign it. And then they don't disclose, I'm assuming they don't disclose these communications if they have to have this meeting to tell Kayla.
That is correct.
So, it's confusing to me. It seems like, Melnick might have became aware and then eventually gets into some email. There's awareness of this immunity deal, but none of the conversations, none of the terms of the agreement are disclosed because there really isn't a two-sided term of the agreement. Woody said, I'm going to plead the fifth, and then they run on their own. Like, this is really not a good look.
No, because like in a perfect example would be Woody say to his attorney, like, hey, I want to testify, but I know I'm going to say some things that'll get me in trouble. Can you get me a deal? And so Melnick approaches the state and says, hey, my client wants to testify, but he wants a deal. And they say, okay, we'll give him blanket immunity. Was it a use immunity? So anything he says, we won't hold against him. Melnick comes back and says, hey, Woody, they're going to give you use immunity. Anything you say is going to be good to go. You could, say that you terminated JFK and they're going to let you slide. And he said, okay, perfect. And so then he would go and testify. But Woody is saying, I ain't want to testify at all. I was going to plead the fifth to get me out of it. But they are compelling me and forcing me as if there was a dialogue and an exchange. Because I'm kind of interested in this. We just gave it to him without asking him. That's kind of weird. I can't wait.
Because that's always a term. I mean, we see it with some of the lower plea deals where immunity isn't fully given, but we go back to Trontavious Stevens, YSL slug. I mean, he got a plea deal. He was wrapped up for something. He wasn't given an indictment. He was sitting for 7 months in a jail that's falling apart. He kept asking for bond. And then finally, when they decide they need to secure his testimony, a plea deal drops in front of him. And he says, as long as I agree not to testify truthfully to the innocence of anybody named in this indictment, the terms of this deal, I'm agreeing to it.
Wow.
And that's not for immunity. That's just to get this plea to get out of where you're currently sitting without bond.
Mm-hmm.
And here you're speaking to someone with Woody, and Hilton knows whatever she knows or knows whatever she doesn't know. But whatever she needs him to say on the stand is so important for this case that she just walked up to Judge Glanville saying, hey, can you sign this order for immunity, sign off on this? On a one-way agreement.
Amazing.
She didn't even secure something in exchange. She was going to force the exchange, which would mean it's just her choice.
That is correct.
She is well aware if she is suborning perjury at the end of the day, she's the one that designed it.
Mm.
She can't say that Copeland played her because Copeland never said
that he would do
look,
this.
I'll tell the truth if you protect me. That wasn't why Hilton moved to do anything. Hilton did it purely to secure the testimony. This is really not good. This is worse seeing this than what was alleged in that affidavit.
Yes. All right. I don't know where I cut you off. I do apologize. Or was it me?
I think we're at 25, right? So that's what he's trying to say. He was trying to say he didn't ask for this. And then Hilton says, but he doesn't have to ask for it. Now that we have given it to him, because that's on us. So now that we have given it to him, it's an order. He can still choose if this is the road he wants to take, then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried. Not just these 6, the other ones too. So this is Hilton. This is like check mark again for the affidavit being correct.
Wow. All right. So I done did longer time.
All right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record, the state does not want you in custody. What the state would like you to do is purge yourself from...
What purge yourself mean?
Meaning that you're no longer in custody and that the way you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you is you refusing to testify.
So do you have any questions, any other questions, basically, if you invoke the fifth, I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor.
This is your insurance. I don't know if you want to break that down to him. Kayla says, well, he doesn't want that.
But he's been given it. This is a gift that nobody asked for. Like you can't, I'm sorry. It's kind of like a timeshare. Like I give you a timeshare. Like that's what this is. It's like a timeshare. Like nobody wanted it. I didn't ask for this. It's not a gift. It costs more to maintain it, but You've been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege, which is what he wanted to do. Okay, but
and they took that right.
they took
Your
it
right
away
to
from him. They
invoke the
took the
Fifth
privilege away
Amendment
from him.
privilege is your right, and they took it away from him without it being his choice.
That is correct. But what the state decided is they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made from the state's perspective, they have made a decision to give you immunity so you no longer can invoke your Fifth Amendment privilege. You have to testify. That is wild.
I know the attorneys the LawTube attorneys are going to they're going to love these transcripts, guys. This is not good.
This is, and again, the point is you have the right to plead the Fifth. They basically remove that from you and say and they're compelling you to testify, even though you wanted to plead the Fifth.
And I want to be clear here that Glanville signed off on this immunity order.
Wow.
So it's not like he's just trying to make sense of this as it's being presented to him in chambers on Monday morning on June 10th. He had to have signed this order. Did they say Thursday night or Friday morning?
Okay,
Whatever
I think it's Friday morning.
Friday morning.
Friday morning.
So, he was already... At that point, if he signed off on that order on Friday morning, he had to already be aware of the circumstances why he was giving this immunity agreement. So either he was misled by Miss Hilton, and Miss Hilton said it was for another reason.
Wow.
Or Miss Hilton told him flat out, we're doing this to secure his testimony, which she's clarifying here in chambers with him on this Monday. So even if he was misled Friday morning, it's clear now what the reason is. So Glanville can't be playing dumb Monday, Tuesday, Wednesday, when all these defense attorneys start inquiring about what's going on. Because if not Friday morning, he was already well aware of this agreement deal, this immunity deal, being forced upon Woody. And at that point, that's extremely prejudicial to the defense. Because they're at a position where not only was none of this disclosed, but someone who wanted to plead the Fifth, which they could have done if they didn't have this immunity deal forced on them.
Correct. So
he could have pled the Fifth on the stand, and a reasonable juror could have made the inference, well, if they're being asked about something the defendants apparently did, but they're saying I plead the Fifth, well, then the defense might be innocent of that charge. And that opportunity was now robbed without disclosure from the defendants.
And the court is complicit in it. So let me finish. So that's the difference in this particular scenario, is that they have taken away, well, you can still invoke your Fifth Amendment privilege. You still can do that. But the consequence of invoking it is you will just remain in custody. But he doesn't have to, though. Am I wrong? Wow. So if you testify, you get out of custody and you stay out of custody until you are done. Until you are done, Mr. Copeland. And then if I don't testify, I don't have to stay in there. I have to stay in there until when? Until the trial is over, until all the defendants have been. I've got these 6 that we have right now, and then there's another 6. So Glanville is complicit in this. This is not just...
So this is another check on the affidavit. This is a specific detail that Glanville then came in and emphasized that it would be even longer. So that's another thing the affidavit... they got specifics.
Look at
They
Hilton.
weren't just getting inklings. Yeah. No, there's another 12.
Wow. There's another 12 or thereabout that are still outstanding in various forms or another. So he's telling them, you're going to stay in jail until your beard is gray as dear woke Christians. That's literally what he's saying. Wow. This is not good. I can see what took him so long. He probably been praying, probably putting in some job applications, because he's going to be looking for...
Honestly, he's probably well, at least Hilton looks way worse than I look, at the very least.
I have to say, let me say that. Hilton looks a lot more gangster than Love did. Because, by the way, you notice Love is quiet. If Love is still in this discussion, she's sitting back scribbling sticky notes. Because this is all Hilton in here strong-arming. All right. Can I speak with her for a second? Yeah, sure. Judge Glanville's.
Okay, hold on. So love
Okay.
isn't mentioned in this paragraph here.
You're right. She's not.
Okay, so Glanville, Hilton, the court reporter and investigators Antonio Long and Rasheem Hamilton leave the chambers. Because again, this is going to be an attorney-client conversation, you guys, between 10:17 and 10:33. And this is that conversation that was
16 minutes.
misrepresented as being like over an hour long, and now we're getting the correct transcript timestamps.
Right.
And it was not an hour long. What is this math? 16 minutes?
Yeah, this is now granted, now let's give a little bit of grace. Glanville has no concept of time. So
yeah, no concept of time, and
16 minutes
reading
could
numbers
be
on
an
a
hour.
paper.
16 minutes could be an hour because this is the 3 hour comfort 3 hour 5-minute comfort break. Mr. Copeland, my question is, I can ask you a question. Court, yes. So my question is, so what I was just asking her was, if you ask me a question and you feel as in I was lying about it, you will lock me back up?
No, so you're saying, you say, I didn't talk to Demikian. Well, no, I can't talk about that because the judge is in here. You're asking, for example, if you, oh my God, this is the, guys, if you said before that the sky was blue and I asked you on the stand, what color is the sky? And you say, I said it was red. I'm going to say, no, back before you said it was blue. Is that what you're trying to ask me? And then Bumpus says, So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? Hilton says, if he said he did something and he did not do that thing, Bumpus, if you believe he did not. So if you believe that he's lying about that, Hilton, then no. If he admits to doing something on the stand, and he did not do that thing, I'm going to say, is this the first time you are saying that? Bumpus, and do you have independent evidence to prove it wasn't him? Then what? Hilton, then nothing. What do you mean? Like, Bumpus, so then he will be fine. Guys, this is the affidavit being checked off again.
Wow.
Hilton, yes, but, and then Bumpus, so you're okay with him if he got on the stand and said things that weren't true? Hilton, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. Now, this could have been a simple yes or no answer, but here we go.
Right.
If you say something that is inconsistent with what you said before, then I'm going to ask about the inconsistencies. But I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth. But I will deal with you, not you saying something different in the manner that I normally do.
If I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them.
Okay, so you can say, I don't recall. That is how this works. I don't recall. Bumpus says, and he can just say that to every single question? Hilton, I would hope that that is not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall.
What will get me locked up?
What did I tell you?
I don't know.
What you did on Friday, I plead the fifth. If the court instructs you...
So the only thing that gets me locked up is pleading the fifth?
And Bumpus says, yes. And then Hilton says, the court instructs you, you need to answer the question. You say again, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up.
So if you don't want me in jail, why you just don't let me go after the trial over with?
You're in jail because you're not answering the questions.
Because you have been given immunity.
Because you've been given immunity. You were only in jail because you got up here.
Well, what about this? I answer the questions. You take away immunity. I answer the questions and I plead the fifth.
No.
Oh, wait, let me see. Wait, hold on. You take away immunity. Because again, immunity is what he didn't want. I answered the questions. Well, he wouldn't be answering the questions if he pled the fifth.
He's saying, if we were at wherever we were on Thursday before you took it upon yourself to run and go get this order signed from Judge Glanville, giving me immunity that I didn't ask for and I didn't agree to. If we go back, if we hit the reverse and we go back to where we left off before you went and did that, can I just plead the fifth to something that would incriminate me? And Hilton's like, nope.
Got it. Okay. All right. Let me, I won't plead the fifth to things that don't incriminate me.
Sorry, that's the court.
That's me. The state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure that the jury needs to hear what you have to say, good, bad, or indifferent. And what Miss Hilton is telling you is just tell the truth as you know it, and let her worry about it. I mean, even though you may have said different version of whatever that's for impeachment, that's not going to get you in trouble. What will get you in trouble is if you just invoking the Fifth Amendment privilege because you have been given immunity, or as Ms. Love said this morning, remember Ms. Love said, by the way, Ms. Love is not in the conversation, but that's a different point. Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on particular charge. I mean, that particular false statement. That's what they're going to do.
And Bumpus says, that is what I was saying. You will be right back here, Hilton. But if you say something that you know you did not do, like you admit to something you know you did not do, whether you...
Like murder don't have no statute of limitations, right? Like murder don't have no statute of limitations, right?
But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it.
But y'all don't.
And Kayla says, you can charge him with false statements and he will be back in jail. That is what I'm trying to say. Hilton says, but if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. Check off the affidavit.
Wow.
But I'm not going to charge you because I know you didn't do what you're trying to say you did now. And that can be part of this. I know you didn't do it.
Wow. But that's up to the judge to do that.
No, it's up to the state to bring charges.
I don't have anything to do with that.
He has nothing to do with bringing charges. That's up to the state of Georgia.
Can I talk to my family and I will make my decision right after I hang up the phone?
Guys, that's crazy because that means he's thinking about not just staying for the whole trial, but sticking it out through all the trials for the other defendants.
Right.
Why else would he want to speak to his family before making this decision?
Absolutely.
When he's asked 2 or 3 times now about how long, this trial or beyond it. So, Ms. Bumpus, he's saying he hasn't been able to speak to anybody. Hilton, his sister just called us.
Y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, no nothing. What is a PIN number? Okay.
Maybe to call someone? I don't know.
Yeah.
Chat, help us out.
It was a PIN number.
Says, yeah, we have no knowledge. We did not know that you, Bumpus. He hasn't been able to do anything, speak to anyone.
Wow. The jail system down, but y'all still putting people in.
Oh, the PIN number is the prisoner identification number.
Oh,
right?
That's what it is? Okay.
Is someone in the chat? Now that he said that, now I get it. Is it prisoner identification number?
I think so.
Because I think I've seen it, that, and then sometimes it's a jail identification number, like a JIN. Now I recognize the acronym in context. So the system's down. They can't even give him a number, and they're still putting people in, which does not surprise me to hear. And then Hilton says, that part I didn't know. I know we have been in communication with your sister. Your sister actually texted Miss Lancequote to make sure you were okay. We told her we physically had laid eyes on you. I'll leave that up to the sheriffs. I don't know. Brief pause.
Wow. So what you think what she's saying?
I think that might be like, so what you think? What's she saying?
Yeah, am I saying
Maybe.
it? Yeah, it should have been so what you think what she's saying? Yeah, yeah.
And then Hilton says, I can tell you right now.
I'm talking about that locking me back up. So he's clearly thinking about going back to jail. You're right.
And what his sister's saying about it.
Yeah.
Because sister might be watching his kids or something, you know?
For sure.
And then Hilton says, we would have to bring charges. There would be no incentive.
Y'all will.
We've already had this discussion.
Look, what you did to me. Look what you did to me. You waited until Friday and did this. Okay, so there goes the immunity on Friday. I done told you.
Well, on the birthday, his kid's birthday.
Yeah. I done told you every day before Friday came that I was pleading the fifth.
No, you did not. As a matter of fact, our last...
Mr. Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the Fifth Amendment privilege. The state could have turned around and said, stop. Had me go ahead and filed that motion and given you immunity. It was going to, they make the decision. They decided to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking a Fifth Amendment privilege. So they give you immunity. That is still amazing. What if he didn't want it? He doesn't want it. They gave you immunity, so you've got to testify truthfully as to what your knowledge of the particular incident is. So they could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that. So I guess immunity is, again, something you cannot deny. You can't say, I don't want that. You've just got to take it.
Yeah, but it was still, the problem here is
Wow.
still the defense has no idea that he planned to plead the fifth, and they knew it for days.
That's problematic as well.
And then they give him immunity, and they know that during this point in time, because if there was no inquiry, right, they would have put Woody back on the stand, and he would have continued to either plan to have tried to plead the fifth and get challenged on it, or he's going to just say something else to avoid saying I plead the fifth. Meaning he's going to be giving dishonest or less than truthful testimony, and the prosecution knows it. And they don't disclose any of this. This is screaming like Brady Giglio violations all over.
Oh, absolutely.
And we knew that from the affidavits, but then just seeing it here is just kind of, you're really seeing the judge. You just got to do it, and it's going to be fine. And I'm aware that you're going to do it.
Does Woody have to sign the immunity agreement?
Apparently not. They haven't said, like, well, you signed it, you agreed to it.
Yeah, they don't say that you signed it. So it just seems like they just give it to you. Again, it's like a timeshare. Like, it's hot potato. And that's what it sounds like.
And the other thing, they keep insisting they want him to have, some type of attorney present for everything to make sure it's understood when he signs off on something. So even if he did sign it, there would have been an indication that Melnick signed off on it, or Bumpus also was there when he signed off on it.
Good point.
And we don't have that because it doesn't exist.
Wow. So can I get it in some type of writing that if I was to testify that if she feels as if I lied about anything, that they won't lock me back up? And then let me have that. Ms. Bumpus hands the document to the court. Brief pause. Mr. Copeland, on page 2 of the order, okay, pursuant to, gotcha. However, no testimony given by Kenneth Copeland as required under the order or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceedings or prosecution for a crime or offense concerning which he testifies under this order. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. Okay. The only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in the state, the United States, or any other state. So basically,
now, hold on, can we pause?
Yeah, go ahead.
Okay, so back on page 44, the previous page, do you see the language there? And both Kayla and Copeland have tried to call this out. So on line 13, where it starts, they start reading the order by line 14 and 15. However, no testimony given by Copeland under this order. And then if you go all the way to the bottom, shall be used in line 18. No testimony given by Copeland shall be used against Kenneth Copeland in any proceeding or prosecution. So his testimony can't be used. That doesn't mean that you can't be prosecuted for something. That just means your own statements can't be used to incriminate you if you are later prosecuted for things you testify to here. And you've heard Copeland ask for clarification on that, and you've heard Ms. Bumpus ask for clarification on that. And every time the Hilton, and then with the help of Judge Glanville, they're like, no, you can't be prosecuted on it. That's not what it says. Well, then they're reading the order here, and it literally says that just the testimony can't be used against you.
Right. So if I'm understanding correctly, let me make sure, put it out on a low shelf for a pre-K law student. If Woody had said that, hey, I did not pay my third grade library fine at Slater Elementary School, that testimony could not be used against them. However, that does not mean that I can't go look at the records and I'd be like, hey, let me talk to Miss Caterpillar. Let me talk to Miss Butterfly about the media specialist. Did Kenneth Copeland did Jason ever pay his library fine? He didn't. Oh, now I can still be prosecuted for that. They just won't use the testimony that I said I did it. But they found all the other evidence because I said I did. This is messed up. Wow.
Yep. And they that's what I'm saying. Like Woody peeped it. Like, he's really not stupid, and they keep talking to him like he's stupid. But sorry, I think you were on line 10 of the next page.
All right, so basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke the Fifth Amendment privilege for failing to testify, you say, I'm not going to testify. All right. So the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. Now, as Ms. Hilton and Ms. Bumpus said earlier, where did love go? Is it because Woody has been involved? Same thing with why Love is not examining Woody. There's something going on with Adrian Love and one of his relatives or something. I heard maybe that's why she's not even in the room. So once he came in the room, it seemed like she disappeared.
Yeah, I don't know. Either that or Love had to be doing something different, or maybe they were just giving the appearance that nothing was going on if Hilton and or Love were walking around invisible to other members of this trial. I don't know.
That's a great question. Yeah, I don't know. I just wonder. Or maybe Hilton and Love are the same person. No, I'm just kidding. Tell the truth. So as Ms. Hilton and Ms. Bumpus said earlier, you may have told or been asked about situations over and over and over again. They may have changed. What the state is asking you to do is tell the versions that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. You said, I will.
This is confusing because impeachment leads to perjury.
That is correct.
And they're trying to draw a line in the sand that's not that distinct of a line between impeachment and perjury. Not every time someone is impeached does it rise to the level of perjury and a DA pursuing perjury charges. But you see how they're trying to separate it here instead of just clearly saying impeachment, you actually can get in trouble for that if the DA decides. And Woody's called it out earlier in this testimony, and you will do that.
Yeah.
He said it. And he says it right here too.
And I had to say this, and I'm not trying to bash Woody. They should break this down and explain this to them. They're using the legal terms that people with, PhDs understand. This dude barely has a GED. So you might need to really explain what impeach means. Sure, he probably does. Sure, he might be playing the game, but at least explain it to him and respect him enough to say, this is what impeach your testimony means. This is what perjury means, so on and so forth. This is what immunity means, whatever. Just really help him understand. Because I think, though I do think he might be playing the game, this doesn't make it look good.
They should cover their tracks. They should make it clear, especially if they're going to run and take the paper and get it on their own and then not explain to him what it means and then threaten to hold him in contempt because he violates something he didn't understand. Like that's wild to me. And you already know my thoughts.
Right. I just think they could make their case a lot better, because sadly, this looks horrible. This looks more horrible than we thought it was when Brian Steele was yelling at Judge Glanville a couple of weeks ago. Like, no, this is so much worse. So Woody said, you said, I will. You will not. You will not. Impeachment is not perjury or false swearing. Okay. But she said, I can purge myself though. See, he doesn't understand perjury and purge. You see what he's saying?
He thinks one's like the verb and predicate.
Yeah.
And then Ms. Hilton says, no. We're saying two different things. Sorry. Perjury is if you get on the stand and you just say a bold-faced lie. Just something that is just wrong. You say, I did something. And all the other times you've said it, I have not done it. And really, while it's perjury, it's really just an inconsistent statement. Like, if you get on the stand and say, I did X, but in 2015 you said, I never did X. That is what we're going to impeach. I'm going to impeach you on everything you said in 2015. Meaning I'm going to say, okay, today you said I did X, but in 2015, and then we have Lieutenant Dean entering the chambers and says, we have a security issue. We need to stop for a minute. If we can, stop for a second, please.
Okay.
So Glanville leaves with Lieutenant Dean for 2 minutes, and they come back between 10:45 and 10:47. And Hilton continues, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense. I said it to you before, and I'll say it to you again in front of all these people. It makes no sense. I guess who you're not saying this in front of?
Judge his attorney.
Yeah, like the defense isn't part of all these people.
Right, because this is really trying to, hey, I'm trying to position like, hey, I'm your friend. I'm looking out for you. I'm working for you. This is that good cop, bad cop, but there isn't. It's actually the bad cop pretending to be the good cop.
Yeah.
You just said I'm going to have to stay in jail until the last. She did say that.
If you don't testify, get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing holding you right now, is the fact that you keep saying, quote, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want you to tell the truth, like I said before. If you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. I gotta say, her way of arguing, this is me interjecting on my own transcript reading, her way of arguing reminds me of when someone does something wrong and they don't want to admit they did something wrong, so they start going on that spiel about, I'm not saying I'm perfect, but it's like every time she says, I want you to get up there and testify, she pauses and interjects and says, I want you to tell the truth, though.
Right.
So I want you to get up there and testify and say what I want you to say. So it's like she adds in these self-serving statements, knowing that this is going to be on the record. So you can't say I told him to lie because I kept telling him he could tell the truth.
That is correct. That's exactly it.
So, and then she says back on line 17, but what I do expect for you to do is answer questions so we can get through this. So you can go home, be with your baby for her birthday.
Wow.
See these dogs deliver their babies, go talk to your nephews, and do all these other things.
How you know about my dogs?
Because you told me.
Okay.
Bumpus says, what's wrong?
I'm stressing at another level, like.
Bumpus says, I'm saying.
I'm weak, man. I'm not playing. I'm dead serious, man. Like.
Hilton, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you have to make Bumpus. If he decides in 2 weeks he wants to testify, then what? Well, if he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. Bumpus, he just feels like he's under a lot of pressure right this second.
Even at the jail, they are just, you can't give me a house. I'm sorry, you can't give me house arrest?
No, you can go home by taking the stand and testifying. That's what you...
And come back tomorrow.
We keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not...
So why am I in jail then?
Because you aren't testifying.
But that ain't nothing wrong. That's not a crime.
Well, it's not a crime, but you're in civil contempt.
2 things. Because you invoked your privilege after you have been given immunity, that is why you are in custody, because you get out by testifying. So you testify, you get out. I still want somebody to explain that, because it seems like if he didn't want it, you're forcing him. Again, you are compelling him to testify, tacitly doing that. But
it's really not that different from the plea agreement strategy, right? So you lock someone up, you hold them without bond, and then you drop a plea deal in front of them to get them out of the jail. But here it's in the reverse order. We subpoena you first, and then if you don't give us what you want, we're going to put you in the jail. So in effect, the same sticks and carrots, the stick is you in the jail and wanting to, the carrot is the outside. So these plea deals versus immunity deal kind of have the same outcome, even though they're a reverse order means
going
to
in
an
different
end.
Order, right? Wow. That's why I was going to bring you. Why I brought you here early today to just inquire about that. You can remain and hold your position of invoking the fifth, or not testifying, but you go back to prison. You go back to jail, because you can't sentence me.
There's no sentence.
There's no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be. I don't know what it is, Your Honor.
So listen, you were in jail for failing to testify.
Failing to testify.
Not for anything else. Not for nothing else. There is no crime. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. We are not charging you. The state charges you. There is nothing we're charging you with. You are only in custody because you have decided not to testify. That is it. Once you decide to testify...
Remember that word you were talking about, purge.
Oh, yeah, sorry.
No problem. Okay, you can purge right now. Purge yourself of jail just by testifying. I can purge and get out of jail? Yes, just by testifying. Not perjury. Purge meaning you can get out of jail. You can get out of jail, out of custody, and just by testifying. And what about the other one? The other word, perjury. That's different.
That's different.
That's a different word, okay? That can get me back in jail?
Yes.
Perjury is...
It's not... What you're saying is not perjury. What you're saying is what we call a prior inconsistent statement. Your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That's a prior inconsistent statement. Now we got to pause here because she argued that it wasn't impeachment by inconsistent statement. It was impeachment by contradiction. And here, What is she saying?
In prior statement.
So then Bumpus says, you've got to make a decision. So if he starts testifying today, he's going to go home today? And then Miss Hilton says, he should, as long as he remains. But if you get up there and be like, if you get up to testifying and then we get into it and you start saying, I plead the fifth, we're going to be back here again. Bumpus says, but if he says he don't recall to everything, he'll be okay? Hilton, I'm not advising that, but so long as he answers the questions, that's fine. So long as he...
I did these crimes. I'm telling you that. Oh.
Check it off. Hilton,
Wow.
okay, I don't know what you're talking about.
Uh-oh.
Oh, Buppa says, I think, are you saying you want to get up there on the stand and say something?
No response.
Did we find out if we could talk to his family? No? And then Hilton says, I mean, if it's okay, we got the sister's number.
As my attorney, you gotta.
If y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you.
Hold on. Judge Glanville handed a document to attorney Kayla Bumpus and exited chambers with Assistant District Attorney Simone Hilton, Investigator Long, Investigator Hamilton, and court reporter Christina Weaver from 10:53 until 11:28. So they're in there together. That's better than 30 minutes.
Yeah, so this is another segment then.
I don't think he mentioned this.
And then they come back.
Okay, so that's about 40 minutes. So let me, not trying to be picky. Remember,
But they're
Glanville
handing
said
him
that
something here. So what is this
what is that
document
document?
that's being handed? Because we hear in the affidavits it was handing over like the statutes, that it was Glanville that handed over the different statutes and stuff.
Perjury, probably. Like, I'm sorry, what pleading the fifth, immunity, all those mean. Maybe broke it down. The court. Okay, all right. Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? Wow. No, Your Honor. Is it your desire to give testimony today? Yes, sir. Okay. All right, then. Do you all have have some clothes for him?
I don't know. Let me go look. What size are you?
I can't hear you.
What size are you?
Little.
So Investigator Hamilton says, we had a large jacket for him on Friday. Large.
Oh my gosh.
And Hilton says, you had a jacket for him? Hamilton says, yes. Hilton, oh, but he can't wear a large.
What is your waist size? 34? 32. Chest, what about that? I'm sorry, what are you? 34? 36? Chest?
Probably 36.
Okay, I'm sorry.
That's okay.
Not in my chest. What you mean? Size.
What size are you? Small or medium?
Small or medium? It's like a Laurel Hardy skit. Like, who's on first? All right.
He's like a parrot.
Say again?
He's like a parrot. He's like, Are you small or medium? Small or medium?
That's him. They are going to try to get some clothes so you don't have to testify wearing your jail uniform, okay? Y'all don't want to show the people how y'all did me? Look.
Tell him, Woody.
Look.
And Hilton says, if we can't find clothes, then you may have to wait till tomorrow. So Hilton's saying, we will not show the jury what we did to you. Guys, witnesses, it's prejudicial for the defendant if they have to sit in the court in front of the jury wearing prison clothes, because it gives the appearance. You start to associate that with guilt. It's prejudicial. But that doesn't apply to witnesses. So the issue here would just be witness credibility, not something that would prejudice the defendant. And Hilton's saying, we are going to go out of the way to make sure this isn't prejudicial. Even though we want you to testify so bad, we went 53 pages insisting how badly we want you to get on the stand and testify.
Wow.
We want so badly for people not to see how we did you, that if we can't find clothes that fit you, you may have to wait till tomorrow. That's nuts.
But they did make him testify in his jail clothes that Monday. After all that, I prefer to go in like this. Oh, well, there we go.
And Hilton says, I understand what your preference is.
Nah, don't hide it. Oh, he's wild.
Kayla says, can you make him put on clothes?
Hilton says, no.
Oh, sorry.
I want to go in there like this.
Fine with me.
All right. Okay. You ain't going to try and lock me back up for this.
So long as you testify, we will get an order to get you released. And Bumpus says today.
Whose copy is this?
And Hilton says, you've got to make sure you come back now. I want to be real clear.
When have I ever ran?
You have not. That's the only thing. You have not.
Whose copy is this?
That was ours. Do you want a copy? You can take it, though. Bumpus says, okay. Hilton says, do you still have yours or you threw it away? Bumpus says, I'm going to give him both of these things so he can have some information. Hilton says, okay. And then Christina Weaver, court reporter, says, are we off the record now?
Are we done?
Bumpus says, yes, I believe so.
Okay, we're good. See everybody downstairs in about 10 minutes. And so that was probably about an hour, knowing Glanville. All right, so, and it was over. Proceedings concluded at 11:31 a.m. All right.
Yeah, then you have Christina Weaver sign off that this is, true and accurate.
Wow. All right, let me see if I can do this right. That was crazy.
That was a lot.
That was a lot. Wow, I did not expect it to be that wild. Okay, so give me your overall, because I want to hear the chat. The chat has been going bananas in here, and I appreciate it. There's almost 500 of y'all watching. Thank you so much. I appreciate Kat, not Williams, for stopping by today.
I had a great time.
This has been
I love transcripts.
Oh, we're not done. We're not done. I just want to make sure let me do this correct. Let me see if I do this right. I might do it wrong. Sorry. I'm trying to get if you're new here, I am not the best with my eCam. Here we go. Let's try it. Okay, I got you here, but I did that wrong. Well, there's my lovely host, but I have no idea why I can't see me. This is crazy. There, I'll just sit there like that for a second while I figure it out. Okay, give me your overall. Give me your overall while I'm figuring this out, what I did wrong. What's your overall opinion of the transcript?
I mean, Woody's not stupid. Even if he doesn't know legalese, he's not stupid. He knows he was being played. He knows the prosecution wanted what they wanted. And, honestly, I think Kayla was really sharp in there. I think Kayla was the sharpest person in there, if not Woody himself. Yeah. Kayla obviously knows a lot more of the legal stuff. But I feel like Hilton and Glanville, and then earlier with Love, they went into these long-winded paragraphs to try to say what they wanted to say when they didn't know how to say it. Because there was no genuine or authentic way or way that was based in an actual law or statute that could say what they wanted to say.
Absolutely. And yeah, I mean, you were wrong from the word go. And I understand there's a couple of reasons why you would have an ex parte meeting, like a temporary protective order, or maybe somebody from the defense had actually threatened Woody. That would make sense. Or if you were just doing like a scheduling, like, hey, we're gonna move some witnesses around because we have a tough witness. We're gonna move him to, later on this summer. We got somebody else coming. That would be fine. This was none of those things. And I feel like Glanville during court today tried to position it like there was a lot of good reasons for having this ex parte, but there really wasn't.
We don't get that. It's like he was happy that the word safety was mentioned, but it was a 2-minute break at 10:45 to 10:47, which is long after everything else took place.
Yeah. And I also
it could have nothing to do with this.
And the fact that the man is literally saying, I don't want immunity. He's basically saying, I don't want this hot potato. You take it back. Just take it back. He doesn't want it. And it was very clear.
You're forcing me to incriminate myself.
Right. And it was very clear that he had no understanding of this. Again, maybe Woody was playing us all. Maybe he's like the smartest guy in the whole room. I don't think that's the case. I think he really did not understand, nor did he want this quote unquote immunity, because it did tacitly take away his privilege. And they make it sound, and I don't know if you can attest to this or maybe you can chime in. It sounds like, well, they gave you immunity. You have no other choice. Like, you got to testify. Yeah. Like, well, what if I want to displead the fifth? Well, you can't do that because they gave you immunity. And I don't see anything that he signed anything. I don't know. Maybe.
It's all going to continue to come out. I mean, this transcription is an absolute win for every single defendant. It's a win for Kayla. I don't think people had that many trust issues with Kayla Bumpus. I think maybe Judge Glanville did, but this exonerates her whether we had doubts in her or not, right? This just exonerates her entirely. And then as far as Woody, I mean, if you had, because I wondered, like, hey, I didn't really understand the stand. I was wondering if he said, all right, I want immunity, and then didn't understand the terms of it.
Correct.
Now that's not the case. That's not the case. He wasn't the one that watched Law and Order and thought he could just ask for immunity and do whatever he wants and say whatever he wants and he's good. It was dropped on him. And Hilton doesn't deny that. She owns that. She's the one that her and Glanville come out and say that. It's their own words that make them look bad.
This is a mess. Okay, where's this going now?
What's your chat saying?
Okay, let's see. The chat has been crazy. So let's get, I'm just going to jump in. First of all, I do want to thank, there was a couple of super chats. I do want to say thank you so much to Retired, who says, remember, DWC, we are all learning and growing with you on your channel. Thank you so much. And I appreciate Kat for coming in to help me as well. And then Heart of Inspiration says, here for the info on the Georgia Witness Immunity Statute. Okay. This information about the Georgia Witness Program. We have to look into that. Thank you so very much. I appreciate it. Very gracious and very kind super chats from both of you. Now, let's go ahead and get some of these other comments going on. I'm going to start from the bottom because they've been fast and furious. It's better than 1,000 comments in here. So, somebody said this, and I think this is really telling that, no, she wants me to really check this out. Okay. While she means that. So let me make sure I pull that up, that super chat, and let me grab that out of there so I can pull this up because it might be something we can look at right here. But some of the comments have been, again, that they feel like the court demonstrated not only that they were not being honest and fair to Woody, but that they were dirty. I mean, I said that is a common phrase, that they're dirty. I'm copying this and trying to do two things at the same time. All right. Got it. Un momento. All right. While that pulls up, give me a second. Got it. Okay. So a lot of people are talking about double jeopardy. Ken Ginger says, operative words for July, double jeopardy. I'm very interested in seeing what ends up happening. Here, this is a great point. I thought Kayla didn't help Woody, but I think she did a great job, given all things being considered. I think knowing that she was just thrown in here. She was a substitute teacher, and everything went left. I mean, that is, she was just a stand-in. She did not expect this. And do you think Melnick knew that it was going to go this bad?
No, and I honestly wonder, he could have just been like, look, they're not letting up. They want you there for some reason. They want someone there. But this is after they ran and got this order signed. It's not like they wanted someone there to have this conversation about getting him to agree to the immunity deal.
I agree.
Kayla is brought into all of this after the contempt. They should have made this fuss to have an attorney present to discuss the terms of this immunity deal before they ran and got Glanville to sign off on it. And they should have disclosed it all to the defense.
Right, which would have made perfect sense. And Heart of Inspiration, I am looking at this. I'm trying to understand. I feel like I got the wrong thing. And again, it could be Jason now. Let's just be honest. It could be Jason. But what I have is this right here, and I don't see what you wanted me to see. So if you could, you don't have to send us another super. Just, put an asterisk by my name or something. I'll make sure I pull it back up. Hearts of Inspiration.
Okay, Transplanted Texan has the correct link now. I think the link got cut off when Hearts of Inspiration pasted it, but the one from Transplanted Texan just now works.
Oh, okay. Let me see what Transplanted just sent me. Hold on. Oh, I see it right here. And what am I looking at? All right, let's pull this back up. Man, this thing's like 95 pages. Look at this. Okay, hold on. Let me pull this in so y'all can see it. Man, this thing's 195 pages, man. All right, what we got here? Okay, let me pull Cat back in. Oh, wait, did wrong. Darn it. All right, here I am. All right, there we go. Can you see it? Can you see it, Cat? Oh, man, what happened to the volume?
Wait for it to be visible on YouTube.
Oh, it's still doing that?
Don't forget.
All right, everybody, I'm
Yeah, I
trying
haven't
my
been able to
best.
see anything from the screen.
Oh, I'm struggle streaming, y'all. Struggle streaming. Y'all pray for me. All right, so the Georgia Witness Immunity Statutes explanation and recommendations for judicial development. Oh my gosh.
Heart of Inspiration says just go to page 2.
Well, thank you so much. Page 2,
Page
right?
2 from the PDF.
Okay, let's zap it up a little bit. In 1975, the Georgia General Assembly enacted a comprehensive witness immunity statute providing for a procedure to obtain the testimony of persons who refuse to testify on self-incrimination grounds. Okay, that would definitely be Woody. I think that's fair. Okay, now, whenever the judgment of the Attorney General or any district attorney to test the testimony of any person or the production of evidence of any kind by any person in any criminal proceedings before a court or grand jury is necessary to the public interest, then the Attorney General or the district attorney may request the Superior Court in writing to so order that a person to testify or produce the evidence. Upon order of the court, that person shall not be excused from testifying or producing any evidence required on the basis of his privilege against self-incrimination, but no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence may be used against the person in any proceedings or prosecution for a crime or offense concerning which he testified or produced evidence under court order. But what about if they say something and that causes the state to now look in that direction? Does that make sense? You know what I mean? Like,
Well, and it's interesting because the language in the order, because it seemed like they read the order in the transcript in the ex parte meeting. And the language is different. And I mean, I guess that they're obviously not going to cite something exactly, because this is a recommendation that they use to form this.
right. Yeah, I just wonder, like, what if they don't want to testify? What if I don't want to? I just don't. Can they? It sounds like they can just make you no matter what. Are you getting that, or am I hallucinating?
So reading the last line that goes into the third page. So on the second page that we were just reading, the last line says, thus the state may not use the witness's testimony or any investigatorial leads derived from that testimony to develop a criminal case against him. Now, in what world, especially what we know about the Fulton County DA, in what world do you think that this Fulton County DA's office would not use any investigatorial leads derived from something that Woody would say under the promise of immunity?
I don't believe that.
So back to you gave the library card, the late fee at the library, that example.
Right.
When you said, I could just go look and see that you have these late fees, even if I'm not going to use your own testimony against you. Now I have the seed sown.
Right.
I have the lead. I know where to go look because I'm using your testimony to go find other evidence to prosecute you with outside of your own words, which, quite frankly, people are prosecuted all of the time without their own words coming into play, right?
Correct.
They can invoke their Fifth Amendment right. Miranda rights, if they're arrested, they're told not to speak. A lot of people will still speak and they shouldn't. But a lot of cases go forward without anyone's own incriminating words, inculpatory statements being used against them.
Absolutely.
So how much does this immunity deal really protect if we don't know for sure that the prosecution will not use what's said as a lead to go and put together another investigation and spring another case up?
I have no idea. And I think that's what Woody is saying. Is that fair?
He knew it. He called it out through the whole
Right.
thing. But
He
you
knew
will
that.
do that. He kept saying, you will do that.
He's already been around this block. Woody is not playing games with him. Thank you so much, Inspired. Thank you so much for that. Yeah, we got some our live chats are amazing. Thank you so much for that. I appreciate it. All right, let's keep going. Lots of people agree with you, Kat. Absolutely. Let me pull this up. Now I can do the live chat properly. Every blue moon, I can do that properly. Lots of good. There's conversation like, well, who's the criminals in this thing? A lot of people wonder, like, well, I thought Woody was supposed to be the criminal, and we're hearing stuff that sounds a lot like y'all are the criminals. Georgia law really is wild, wild west. Hey, don't talk about us down here. We're trying our best. We're trying our best. So here's a question. Retired says, the DA said that the statute of limitations were expired for anything that might charge him with. If that's true, then what does the immunity do for him?
Well, they were just, in my opinion, they were just BSing. They were flubbing through that and trying to come up with a way to assuage Woody's concerns. But they weren't really seeing what the real issue, the real question, the real objection Woody had. The objection Woody had was really, I don't trust you guys as far as I can throw you. But Glanville and Hilton and Love tried to frame his concern as he's concerned about being prosecuted. Well,
Right.
we can't prosecute you for something that's outside the statute of limitations. That's a separate angle, and it's a constrained angle.
I agree.
It's focusing on a scope that you can confidently say we can't prosecute you for, while omitting the other things that you could and should do, even if you're not supposed to. In other words, finding leads and running on those leads, and not just prosecuting you, but if your testimony on the stand is something that involved a group of people, and you testify to something that incriminates you as well as that whole group, now you're putting them all in the line of fire.
No, that's a great point. Because I think it's his concerns were outside, were greater than just prosecution. That he was actually saying, like, you might be putting my life in danger or whatever like that. You put my kids in danger and whatnot like that. I do want to make sure that you know, Kat, did you know that you're in a music video?
Oh, so I just pulled that up to bookmark so I can
No.
watch it after.
No, we're not going to watch it after. We're going to watch it right now.
Yeah, okay, we can watch it now.
Okay, right now. Hold on. I actually have We Watch YouTube has a whole folder on my computer. Hold on one second. I know y'all are like, Jason, your computer skills are suspect at best. But I got it together. I promise you. Okay, ladies and gentlemen, with no further ado, here's a little intermission. Let's have a little intermission. Let's go.
Shout out. I like that. Says leading AV, I put you in music video called Lil Woody.
What you mean?
What you,
What you mean?
What you mean? I guess I don't recall. It's how you beat a Rico. What you mean? Yes, I don't recall. Lil Woody, do you Lil Woody? Do a Lil Woody, what you mean? Well, I did a Rico for the church hole. What you mean?
Can you say that again?
Sure.
Oh my God. Y'all are crazy.
Have you seen that?
Oh, that's new to me.
Really? No, we watch YouTube.
I love the little song too, the Rico jingle.
Oh, yeah. So we watch YouTube as a great supporter of the channel, as well as probably has shown up in yours as well. She does some fantastic videos for us. So she's done a...
Yeah, I just subscribed and I hit the bell because,
Well, there you go.
The bell makes a difference, you guys.
There it does. That it does. Let's see. Criminals with street smart versus criminals with law degrees. Yikes. I might have to get a little... I'm going to bring a sound effect to that one. That was great. Yeah, this is coercion at its best. This is... I'm sorry. I can't think of another way to frame this. Like that. This is coercion.
It's like mind games a little bit too. They think that they're playing one up on against Woody with mind games. And I don't really want to say he's even playing mind games back. He's pretty forthcoming and straightforward in his responses.
That's fair.
He's literally not playing games. But his answers aren't the answer that the prosecution wants. So they're treating it like he's being difficult or misleading. But really, he's just being honest.
Right.
He's being honest. This is the only time I'm being truthful is right now with you guys. That I'm a liar all the time.
I mean, he said that. He did say that. He could say something they know nothing about that isn't outside the statute of limitations. All right, what would it be? Yeah, I get.
I mean, it doesn't matter. It could be anything that could have happened. Even if it's just like assault, it's 4 years in Georgia for assault. So from anything since 2020, really since mid 2019, could incriminate him.
Yeah,
and a murder doesn't have a statute of limitations. That's why he asked that question.
There you go. All right, let's see. Is immunity like a knee on his neck? Dang if you don't. Dang if you don't. No, I mean really. Dang if you do. Dang if you don't. I agree, man. Like I don't understand. And even reading the statute from the Emory law, I don't get like, what if I just don't want the immunity? So they can just force immunity on you and put you out here to have to testify. That's wild.
Yeah.
All right.
I mean, this is. Does anyone in the chat think that this looks better for the prosecution or the judge than if we didn't see these transcripts?
Yeah, in the chat, if you feel like, you know what, let's go with a 1 if you think that it makes them look better, and a 2 if not. If you think it makes them look worse, a 1 if you think it makes them look better, and a 2 if it makes them look worse. I think we all know where we're going.
It's a pretty give me question.
And it's a great point. Like, how honest can you be other than to say, I told the cops whatever I could make up to get out of jail? Like, how much more honest could you be? And I see right here, there's a lot of 2s coming in. The 2s are on fire. Is that a 2-person? What is that? It makes it look worse. I agree. It makes it look worse. No way the judge of prosecution comes out looking good. I agree. 1 million. Okay. I can dig it. Immunity was forced upon Susan McDougal, and she chose doing the time. I forgot that. Okay. You know what? I think I do kind of remember that. Do you remember that, Kat?
Vaguely.
Yeah.
But we didn't get that much of a commotion about that.
So this is a great question from Moses.
Now I'm curious if they're going to bring.
Like, this is a great question. How many other ex parte meetings has the ADA and the judge have had with other witnesses? I think it's a great question.
I just looked up. Susan McDougal was 3 questions. So, and let me be clear. So again, that was actually a long time. I was young. That was 2020 or 2001, 1995. When was that trial?
You making me lie. You gonna make me lie. I'm trying not to lie.
Well, I'm just thinking, I'm going to think there wasn't such a big fuss about it because I was little. I wasn't into it. So this could have been, you guys in the chat have to let me know, this could have been as big of news as what's going on with Brian Steele and Judge Glanville and all of that. I was young, so I would not have registered the popularity of Susan McDougal.
I don't think anything that happened pre-2000 is even, we're in a new era as it relates to just social media in general. Because if that was pre-2020, pre-2000, that old era bygone, I think we're talking about something totally different, in my opinion. Because I can only imagine what the O.J. Simpson trial would have been like if we had social media. It would have been crazy.
Well, with Susan McDougal, I know that it was I know about her less because of the Whitewater stuff and more because she was held in solitary confinement as part of the contempt, I believe.
Mm-hmm.
So that came up as an issue. That's you're being held in civil contempt for, it was a long time that she was held. I don't know the exact duration, but it also involves solitary confinement. Now imagine you're being held for a long time plus in solitary confinement for civil contempt.
That would be crazy.
You don't have a criminal hearing. You don't have a chance as a defendant to defend yourself. You're just put in to solitary confinement.
Right. Al says this, and it does kind of seem like this is it. So the Fifth Amendment right is only when you're the defendant. That's what it seems like. I'm not saying they're right, but that's what I'm getting. What do you think?
No, you can plead the fifth against self-incrimination, even if you're not the party that's on trial.
Well, no, it seems like in this case, that would be the only people that could get away with it, because Woody can't, is what I think what Al is saying, basically.
Meaning
Like,
post deal, right? Because they're saying that the witness we gave you this immunity deal. Now you
Right.
can't actually plead the fifth.
right.
But technically, as a witness who's being asked to testify, really being forced to testify, they can refuse to answer certain things that would incriminate themselves. But then they throw the immunity deal in the mix. So the Fifth Amendment does apply to people other than the defendants. They're just saying that the immunity deal coming into play means, nope, doesn't matter anymore. You can't
Man.
invoke your Fifth Amendment rights.
That's got to be the craziest thing in the world. Like, you cannot.
It's a catch-22.
Oh yeah, for sure.
And how does that lead to a fair trial for the defendants?
Mm-mm.
If you're a key witness, this isn't even just like a side witness. This is just like,
Yeah. Okay, let's see what we got. Okay. Sunshine says she telling everything. She holding nothing back. She ain't pleading the fifth. She is telling everything. I love it. All right. Oh, here's Transplanted. If you were looking for information on that Susan McDougal commentary, here's a Transplanted Texan. Drop that in the chat. Thank you so much. Woody would never make a deal, though. I kind of wonder what would have happened. How would this conversation have gone if Melnick was in the room instead of Bumpus? And how would this conversation have gone if the defense was able to be there? Well, we all know it probably wouldn't have happened. But even if Melnick was there, would this conversation have gone differently if Jonathan Melnick was there?
so this is not to be critical of Kayla Bumpus. This is just people have different styles in their argumentation. Kayla Bumpus pointed out very plain, it's from the reading of the transcript. She just said, well, wouldn't that mean blank? And she left it at that. Melnick, the way he was in court arguing with Glanville on that Friday,
Yes.
is a little bit more punchy. Again,
Sure.
different stylistically from Brian, but a lot more punchy. I would imagine if he was in that room, he would have been ripping them to shreds about how they were trying to toy back and forth with what the statutes say and their behavior in trying to, withhold this. I feel like he would have called out, because he already knew.
He was aware.
He would have called out that you still haven't brought any of this to the defense attorneys. Why do you keep calling these meetings and having us come in here to keep trying to get my client or my not client, whatever he is today,
right?
to not testify or to testify to what you want him to testify to? But all along, you haven't disclosed what's going on to the defense attorneys, and we're standing in here right now without them present. And I'm saying that because I think at the end of the day, it was Melnick that ended up telling. Whether he got the information initially from Kayla or from Woody, I think it's really a good chance now, looking at this, that it was Melnick that.
Oh, no question about it. No question. I think you're right. I don't know how he got the information from the Star Chamber, whether, again, Kayla or Woody. I don't think that matters. I have my opinion, but I don't want to go there. However, I think at the end of the day, I think it was Melnick that told Brian what was going on. Because, again, it was almost verbatim what was happening.
Yeah.
I think Gloria is onto something here. If you can force an immunity deal on you, you no longer really have rights. I mean, I think that's what I was getting from Woody's pushback. Oh, and by the way, if Melnick had been there, I don't think all that in the beginning where ADA Love was saying, we don't know if Melnick is his attorney or whatever like that. I think that would have been quashed because he would have been there, right there in the spot. So I think all that opening salvo, those first 2 or 3 pages, would not have happened, in my opinion.
Yeah, no, I agree.
What about this? Do you know when the recusal hearing is actually going to be?
No, but it is an emergency petition for at least at least Doug Weinstein's is filed as an emergency petition
That's
for
correct.
a writ of mandamus. I feel like all the others were too. Well, no, he's the only one that filed the writ of mandamus to order a court to do something. So the recusal motions are just being referred to, sent over to another judge. But Doug Weinstein's filing is actually a petition for a writ of mandamus, an emergency petition requesting emergency relief.
Right.
And again, I think that's the number one reason we had Judge Glanville say, all right, I'm making all these arguments on the record in court today. We're going to take this in-camera meeting and actually let it be televised so everyone can hear me argue for my own self, right? I want all these people out that know about this case to hear my argument about why this ex parte meeting was not a violation. And I'm going to get on the record that I'm the one volunteering the transcript, and I'm the one sending these other motions to recuse over to a different judge. But still, this Doug Weinstein motion for Yak Gotti is an emergency petition. And there's still certain relief that's requested in a timely manner. We still have a sworn witness. We have a jury that's out waiting. We don't even know when they're coming back.
Right.
So the emergency situation hasn't gone away just because trials paused. Trial should have been paused Monday, June 10th.
Easily. I personally think it should have probably been, but definitely then. Monday, June. So we've gone a month, almost a month, 3 weeks.
Yeah, we're just shy.
Well over shelf life. We should have stopped on the 10th. But somebody asked a question. I thought it was good. This is a great point. Second key witness is telling everybody he lies after the first witness, the high goddess, Mr. Bean, hinted that he had been coerced. I think Mr. Bean made a great point that he was coerced. So going back to someone's question before, how many of these ex parte meetings did you have? Did you have one with Mr. Bean? Did Bean, was he forced to do this? And he just didn't, he was forced to it, but he wasn't willing to say he was going to plead the fifth because he knew that he didn't need to. But they just said, you got to testify. He was the guy that said, literally, can I leave now? Can I go home? I don't want to be here. But Judge Glanville said, no, you got to still be here. So I'm wondering, like, hey, was he coerced? Was he, arm twisted, whatever, to do this? What do you think?
I mean, look, like I said, when we first started this stream, it's a pattern. So it wouldn't be reasonable to just assume it was one mistake or one bit of incompetence that led to an accident. It's a pattern now. The reasonable explanation for it, Occam's razor, would suggest that it's on purpose.
Facts. And I think right here, they may not have tried this if Melnick was in town. That's what Laura said, and I agree with her. Now, CJK kind of summarized basically the whole conversation. You can't plead the fifth with immunity. The problem is, what if he didn't want the immunity? Is what I think we're getting from Woody, is that he didn't want the immunity. He just did not want to testify for whatever reason. And I think that's what I'm getting from him. Is that fair?
To me, it seems like he doesn't want to incriminate himself because he understood that he could say, I don't recall.
Yeah. And, I mean, this kind of goes, Sunshine's nailing it again. Like they're wrong. Oh, wait. Let me I see it's a two-part, sorry. He said he was going to report ADA Love. Why? For speaking to his client, knowing that he had representation. Yikes. I mean, I think this is a wrap. I'm sorry. I don't see.
I think it might be too, especially after reading this transcript. I don't see how another judge could ignore and turn a blind eye to this transcript. Because again, now what we're going to be dealing with is a motion not just to recuse from, he's no longer hearing this show cause, he's canceled that. But as far as sitting as the judge for the remainder of this trial, we're looking at something that could warrant his removal. And if it warrants his removal, why does it not also warrant the prosecution's removal? Because they were in tandem in that meeting. And then you have misconduct by the judge, you have misconduct by the prosecution. Like, that should be a mistrial.
I agree.
And you can't turn your eye to it after seeing this transcript.
Yeah. This right here, this comment right here, you're not ready for. Everybody, real quick, in the chat, just write the word Ken, K-E-N, Ken. Why are we writing Ken, Jason? Why are we doing this? Listen to what he said. I wonder why they brought the court reporter in. They were like, we're crooked enough, witness tampering, but we draw the line at off the record. So I think that's right. Like, why did they have a court reporter in there if they were doing wrong? Unless they were very comfortable doing wrong. And they just got comfortable. So again, are there other records of him having these meetings with other witnesses? Because there have been tons of witnesses on there that have been a little bit, shall we say, not the best. Again, looking at Bean. So is it possible that they were doing this before and they just said, whatever, nobody's gonna know? Because imagine if nobody had found this out.
They're going to have Max Sharp like looking through papers and papers of transcript requests. And I wonder, like, this one was released by Glanville or whatever, but
Yes.
I'm sure if the defense attorneys are requesting the transcripts otherwise, they have to pay per page. I don't know what the rates are in Georgia, but I requested some transcripts in New York, and I'm very grateful that people helped crowdfund it because it was anywhere from $4.55 to $7.20 a page, depending on the turnaround time.
Wow.
So if you wanted to wait more than 2 weeks, you could get it down to as low as $4.50, I think was the bottom bar. But if you needed a turnaround time, which is if you're an attorney that needs to argue something in court the next morning, that turnaround time in New York is over $7 a page.
Wow.
So, and that's all billed through to a client if you're private counsel.
For sure.
But like, think about like indigent, like how can an indigent defendant with a public defender, like what's the remedy there? How do they request these transcripts to be able to call things up? And Georgia might be cheaper. I think New York might be on the extreme end. But yeah.
Well, I think like
it's
sense
page to download this, and it was e-filed.
Yo. So somebody said, I applaud Glanville for giving the entire transcript, knowing that this has killed this case. I mean, I feel like it's torpedoed the case. I don't think there's much remedy or way to bring this back after this. Sure, it might not be the worst thing that a judge has ever done. Sure. But I think we can agree that this is pretty bad. Somebody asked a moment ago when the recusal hearing was set. There's no date set. Retired said. And if you do see it, please drop it in the chat and we'll make sure we get it up here. I think Kayla was bombarded. I saw that comment. I do think it was definitely outside of what she was expecting. Because again, I've heard her several times on different shows. Kayla, where you at? I'd love to have you on here. But I heard on different shows, and it sounds like she literally was just like, I'm just coming in. I'm going to stand there. He's going to purge his contempt, and we're going to sign this document, and I'll be on the plane. That's kind of what I understood. And it's gone totally left. It went way out of control.
Well, she tried to reiterate that like twice during that transcript. Like, the whole trial? You want me to stay for all of it? What? Yeah. Like, it wasn't clicking to the judge or to Hilton or Love. I think one time it was with Love and one time it was with Hilton it was just with Hilton, that she should be gone once the contempt is purged. I
agree. And that was the agreement. Did you hear anything about what was that security concern? It was only like 3 minutes or 2 minutes that Glanville deputy came out and said. I didn't hear what it was either.
No.
It was Gackle getting warmed up. The strike force was coming in.
Oh, maybe. Well,
no, it was Gackle was.
You would have known that at 10:45.
No, that was well after.
It was only 2 minutes, so it sounds like someone was like whispering in the ear.
Yeah. So I have no idea.
It honestly could be like, hey, infamous Sylvia and George Cheedy, they're back in the building. They're the ones that, we talked to. We said that they couldn't take pictures in the hallway. Well, what about today? Because Woody's still in jail clothes right now. So should they be photographing him? Your order on Friday, should they still be photographing him? Should they be in the hallway able to observe this?
That's a great
question.
Screw
the Rule 22
right.
Access to the press. But that really could have been it if it was just a 2-minute whisper in the ear.
That could have been it. I like that. Cosmic Cat said, can Kayla talk now that the transcript is out? I know she's going to be on, I'm sure she's going to be somewhere soon, kind of going through this play-by-play where Kat and I were reading it out. I'm sure she'll probably read her own and talk about what it was, what was actually happening and give us a little bit more color. So I'm sure expect to see Kayla Bumpus somewhere real soon. Let's see. A lot of people speculating where 88 Love was. Miss Love, like, bye, run for your life. I mean, I think she just threw her to the wolves. I'm like, Where was she? She wasn't even there today.
She is posting on X.
Who, Kayla?
Yeah.
Okay.
On the
I'm with-
account that I didn't think was hers, and then it actually is hers.
It is hers.
I thought it was someone just pretending to be her, knowing that like people are looking for what she says, but it is really her, the PI princess.
Yep, that's her. All right, so most people are saying agree that this case is over with. So I'm gonna drop a poll on here real quick. All right, drop that poll right there. Is this case over with? Feel free to give your feelings about it. Okay, well, there we go. Kayla said after the meeting, she told Melnick what happened. That makes perfect sense. I didn't hear her say that, but that's what I was thinking happened, so I'm not surprised. The court, Justice Matters, says the state can present an immunity order, but the judge signs off on it. The judge did not have to sign it. So do I have to sign it, though? Like, I am the criminal, and Kat is my attorney. And Kat says, Jason, they give me an immunity deal to testify. I say, I don't want to testify. Do I still have to, though? That's the part I feel like Woody in that regard. Like, do I have to still testify? Do I have to take it? And I feel like that's the problem.
Well, in any case, any agreement should have been disclosed to the defense. So,
no question. Yeah. So did they know that he had an immunity agreement before?
well, when did they find out?
When did they find
Maybe
out?
they got inkling of it on Friday, but it was clearly in discussion Monday, Tuesday, Wednesday, Thursday, whatever those days were, and then already signed off on Monday morning.
Yes. No, it would have signed off on Friday.
I meant Friday morning.
Friday morning. Yeah, Friday morning. That's when he got it. But no.
And then was it Shart that called for a mistrial on that Friday when he first said, I plead the fifth? Shart was the first one to jump up and say he wanted a mistrial right then and there on Friday.
I don't remember that. Okay, but yeah, they were yelling mistrial so much I had lost track. Mistrial and motion recused, but I don't remember who did that. But I totally get you. Remember the young lady that was adamant on talking to the judge, the one who was being harassed by the male detectives. The state and the judges have been communicating with witnesses like this. I don't remember this. What is this? Do you remember this?
Let me read it when it comes up on the YouTube screen.
Oh, what? Why is my screen doing this?
I don't know.
Okay, hold on. Try
I'm
something.
still behind. Okay.
Hold on a second. See, that's
Struggle stream.
I'm struggle streaming. See, this does not look right. Okay, all right. I'm sorry. I'm gonna just put it back up and then we'll just go from there. Here it is right here.
Oh, okay, yeah. So the other witness, I can see it on the YouTube stream. The detective was like trying to like promise her like, oh, I'll get you a job. Don't worry about losing your job for coming to talk to me. Like honestly, like as a female, that's recognizable on its face to me as like slick talk, smooth talking, right?
Yeah.
Don't worry, baby girl, I got you is essentially what that translates to.
He said, I got you. The jury will never be back, Retired says. I don't think so. I think it's over.
They're probably crossing their fingers.
Like,
honestly,
look,
if I was a juror, I'd be looking for updates on a mistrial.
I'm trolling Mechanicsville, see if I run into Woody, run around on an ATV so I can take a picture with him. And so I can look. Hey Woody, real quick, let me take a picture with you. Thanks, man. All
Hilarious. Because then you have to force the prosecution to have an issue with it, right? Because the prosecution doesn't want to have an issue with him talking on social. The defense doesn't want to have an issue with it.
But
what about then when it's a juror? If it's a juror,
right.
Just at the 4th of July barbecue, running into cousins that we didn't know we had.
And look, and Woody's my cousin. I didn't even know it. All right, let's see. I didn't even know he was my cousin, but now I'm finding you. All right. The girl that testified about Thug and them said the same. Really? Marshawn Jones says that interesting. I would definitely believe that there's a pattern of coercion, strong encouragement. I don't want to say coercion, just strongly encourage you to do this and do what I tell you to do and do it quickly. I'm just saying. Which would require the Supreme Court of Atlanta. What was that? There's so many comments coming in. It's like messing up when I try to add them to the stream.
I'm so bad at that too. Like for a while, my YouTube videos, it was manageable. I could like have a conversation with everybody, and I love it. And I love being
That's
in your
great.
chat when I'm not on the screen. But it's hard as soon as the chat's moving fast to know. Like you pull up a comment and it's a conversation, a couple comments back, and you come in mid reply. You're like, huh?
So, Katie, I feel comfortable that this is the full transcript. If it weren't the full transcript, that would be, talk about, oh my gosh, if he was putting out a non-clarified redacted transcript or not letting you know that it's redacted, that would just be such a dumpster fire. Just put it all out or don't put it out at all. But to put out half of it and not tell people would be crazy. So I feel comfortable. Do you feel comfortable that was it?
Yeah, I think it matches up with the time stamps. If anything was taken out, I feel like it would have to be one line. And, you know, if it was so significant that they would remove the one line, somebody there is now going to remember that that was, if it was significant enough to remove, it was significant enough for me to remember, why isn't this in here? And I guarantee you, whoever passed on the info about this meeting is rereading through this transcript.
Oh, for sure.
I wouldn't be surprised if Woody's reading through it. Woody's probably in the chat somewhere.
Like, let's go look at his Instagram. Look on his Instagram. He might be reading it out loud.
Next time we do a transcript reading, Woody can read his own voice.
I love it. Can Woody plead the fifth on a cross? Personally, I think he's going to be the defense's witness. So I don't think I think
so too.
Yeah. I don't think he's going to be, well, let's say it like this. He will not be as problematic as he was with ADA Love. But I don't think we're even going to get there. I think this case is done. You know what I mean? I don't think it's going to. But
that might be better for all.
Right.
If he would really get up there and then be asked about if he's the one that committed some of the stuff that's being charged on the other defendants and he wasn't even part of the indictment, like, I think it could save what little integrity might be left of the DA's office. If hypothetically Woody were to get up there and say, look, everything they're trying to charge these people with is something I did. Yeah, they asked me to do this. They gave me this deal. Yeah, they wanted me to say that. Honestly, it doesn't even matter if Woody embellishes because the jury is not supposed to see this transcript. The jury is going to see what Woody would say in open court. So if Woody wants to ham it up and dramatize and tell all during cross-examination, that's just what the jury is going to hear. You can't put the toothpaste back in the tube. Yeah. And I don't think he's in a position. It was palpable when he got back on the stand after missing his child's birthday.
Right.
It was palpable that his demeanor changed and he had basically 2 middle fingers up in the air to Hilton the rest of the time. It's even funnier now reading this transcript and that part where he's like shooing her away because she stinks or whatever.
Right.
Like all of that is so much funnier with this context of the transcript.
I agree.
He wants to stick it to Hilton.
And I think he did. And the bad thing is, and we were kind of wondering, like, well, why? Hilton was much more the bad cop than we thought. But this is something, and I think Justice Matters really summed up, I guess my concern is that, sorry about that, he didn't want immunity. He wanted to plead the fifth. They stripped him of his right, and the judge signed off on it. Unless there's something else, that's what my problem is. The man didn't want to testify, and they took it away from him as an ability to do. Do you agree, or what do you think?
I mean, I think he wanted to not have this contempt order over his head. And what's crazy about that is he was willing to deal with the contempt for the trial length, but he didn't want to go for an additional trial.
Correct.
Right? So he was literally at a point, if we just put an arbitrary amount, let's say 2 years, he may have been fine with 2 years of contempt, but didn't want to do 3 or 4 or 5. So, like, that's really how much he didn't want this immunity deal to be forced on him. to force him to testify.
There we go. And Erica Dickerson says her saying that she emailed him or he emailed her shows that Melnick was telling the truth. And I think that's a good point because it just seems confusing. They keep saying he was, he wasn't. We didn't know, we knew, but you really did. And at least at the bare minimum, you could have said, let's go start with Melnick and ask, are you running point on this guy or not?
Yeah.
But it seems like they just deliberately and intentionally said, I don't know if he's the attorney on record, but they actually did kind of know, or at least should have known and should have at least asked him. But they were going to redact it. They were, but they decided, Red Bunny, to just give the full transcript, and that's what we have tonight.
Now, I saw some chatter about, maybe they removed the part about him saying that he's the one that killed Nut, but I do think that could have been derived from the hypothetical, and maybe not a true hypothetical, but a vague question based in reality about, well, what about murder? There's no statute of limitations for murder.
Correct.
So what if I say I killed somebody?
Right. And since this is what the whole trial's about, you can kind of assume what he's talking about there.
Well, I was gonna say, but what's the problem with that, right? So if there's an inference there that he was the one that did it, and we have the defense attorneys, right? It would be in the interest of the defense attorneys to want to discover a third-party culprit, right? Maybe Woody was the one that is responsible for the murder of Donovan Thomas, of Nutt. But they're saying upon information and belief that this was something that was discussed in the ex parte meeting. So if it was, for example, either Woody said something to Melnick, Kayla said something to Melnick, but Melnick, because he was in maybe Melnick, and this is all hypothetical because I don't know who told who what, but if Melnick in his representation or conversations with Woody in some way, shape, or form was aware, maybe he drew that inference with why that question was asked. What if he was like, well, hey, Mr. Melnick, I asked them, what about murder? Is that cited out of the statute of limitations? And Melnick knew right away what the concern was.
Right.
Maybe something slipped that shouldn't have slipped as a detail over to Weinstein or Steele. Or maybe Steele and Weinstein made the inference without any basis there. I can't say one way or another. I'm just hypothesizing.
No, I think that's...
But I do think the transcript could be 100% valid without that redaction, and the murder conversation is kind of where we get the basis of the affidavit, the statement that upon information and belief, he said that he would state that he was the one that killed Donovan Thomas. So I think somehow we played a telephone game with that one part, and maybe it wasn't something that Glanville pulled out of the transcript.
Right.
Do you get what I'm saying? And that could be a boo-boo if someone made that inference based on what they acquired through attorney-client privilege in representation to Woody.
Because keep in mind, Woody said it in Star Chambers. Somebody relayed that information to Melnick. Melnick relayed that message to Brian Steele, who announced it in open court. So like you're saying, like is a colossal game of telephone between these people, and a lot of information could have been added or could have been embellished between Woody, the person that told Melnick to Brian, to the whole open court. So I agree with you 100%. But here's a good point right here. Did the judge inquire if Woody had a lawyer before signing the order forcing him to testify? And I still don't see that Woody had to sign the immunity deal. You know what I mean?
And then they were just saying that as of Friday or whatever, Hilton was taking the position that Melnick was injecting himself. What's the connotation around the word injecting? It's like you're not really supposed to be there, but you're butting your way in.
That is correct.
So put that in the context of the question of if Glanville was curious, well, does he have counsel right now? And Hilton's meeting with him in the car in the neighborhood or whatever.
Yeah, what was that?
2 or 3 different that people.
But
that seems like something an investigator might do, but it's weird that it was Hilton herself. But maybe we're missing details because she was trying to speak quickly, but it seems weird.
But Bean said the same thing. Bean told Brian Steele, like we talked outside of Kroger. So during cross, and he, because Brian Steele was doing the same thing. Do you remember what did you say on this date and whatever? And he's like, and he mentioned like we talked outside of Kroger. So there's this, I don't know who's supposed to be doing that, but apparently talking out in the open in the hood is not weird, because that just seemed weird to me.
Well, and it also screams, if you're meeting with someone like Woody, who you're saying is concerned for his safety, but you're meeting them there, is there really a concern for safety?
I don't think so.
If you're comfortable, like, that doesn't make sense.
No, I agree 100%.
Especially on a televised trial where people can recognize Love or Hilton. Well, it's Hilton, but people can recognize Hilton at this point.
Yeah. I agree with Moses right here. Moses just says, remember, if you get caught one time, you probably got away with it 10 times before. And I think that's a very valid point. So let's keep this going. There's some good comments in here. Lots of good comments. Kat, you got a lot of fans here that appreciate you. By the way, This is Kat. This is Kat Not Williams from Kat Not Williams on YouTube. I believe the moderators have dropped her link in the chat a couple times. So please make sure you go check out what she's doing. She does a great job of reading these cases, following along. And as you can tell, she's definitely not a pre-K law student like myself. So we appreciate you. Thank you for hanging out with us today.
Thank you so much for having me. Thanks for being my transcript reading partner. I love reading transcripts.
I missed what y'all was asking me. Oh, Ken, you did a great job. I forgot the comment that you made, but it was a great comment. So shout out to Ken. Let's see what we got here. Okay, how about this theory? I got a lot of conspiracies. Okay, what if Glanville did this to get kicked off the case because he didn't want to recuse, but he did want to get off of it? He's like, man, this thing's going crazy, and I got 3 more years to retirement. What am I crazy, or what do you think?
I don't know. I honestly think he did it because he was named in a new case, right? So that petition for writ of mandamus had a unique, it's a standalone case in front of another judge. This is really where it became real for him, because he was trying to kick the can down the road and, cover his eyes. And I really think that this Monday turnaround was it. I don't really think that the transcript was his decision to get out of the case, but rather get out of further fallout.
No, I agree.
When he could have on June 10th, he could have just said, look, Brian Steele, I was going to disclose this with you. We're going to give you these disclosures, but I'm just trying to get the jury in right now. And maybe Steele would have pushed back and said, no, we need to do it now. And then Glanville could have said, all right, we're going to prosecution, make your disclosures that you're supposed to make, and we'll move on. I really think he could have saved face on June 10th, and he didn't. He really didn't. He doubled down for 2 weeks. And now he said, I got to get out while I still have this much life left.
No, I can dig it. I think part of his chest beating and yelling back and forth at Brian, I think that really put him in a bad spot. Because I think if he had not gone nuclear on Brian, he could have easily just said, hey, meet me in chambers afterwards. They could have, arm wrestled or whatever, fought, and then been okay. But because he did that and put him in contempt in open court, I think that's where problems really happen. But that's my 2 cents.
Agreed. I agree.
All right. So Ms. Davis says, isn't it in the law that a judge in another county has to decide, like you can't be another circuit judge or something like that? I have never heard that before, but they've selected a new judge. Some people say she's good. Some people say she's not. I think even if she's not a good judge, I think she's going, since the world is looking at her, I think it's fair to say that she's going to have to do the right thing. Kat, why do you think this case has garnered so much attention? And by the way, thank you all so much for the comments. There's some great comments in here. Please don't think I'm just ignoring you, but there's a ton of them. But why do you think this case has garnered so much attention? It's literally everywhere.
I mean, I think there's been humorous and entertaining parts of it. So there's been people that have been following since day one. There's accessible coverage. But at the same time, as much as it's accessible, everything's on a bell curve, right? Something that's 100 days long and accessible, it's not practical for most people to follow. But when
Right.
it's entertaining, when you have clips like, well, it was a bean that said, "I'm so high right now,"
I'm
like
gonna fall
you
asleep
have
on y'all.
moments, yeah, you have moments like that, and it's just like, all right, we're all tuned in now because did this really happen? This is funny. Honestly, the humanizing moments kind of make it easier and worthwhile to pay attention to, even if the time requirement to follow the case would normally box people out from paying attention.
I
So,
will. I will admit now. Sadly, this case has been going on for almost a year and a half, going on almost 2 years. One of the things that I remember about this case when I first heard it was the fact that they were using rap lyrics to determine. And I remember hearing that and I was like, wow, that is so interesting that they're actually using lyrics to songs. Whether you agree with it or not, whether you like it or not, I do have some problems with the music that is being portrayed. And I think I did a video with Brian Steele is basically talking about it. It's art. And I do disagree with Brian Steele. I think it's not just art. The lyrics and the songs that they're talking about, it's something different. And if you
well, when
look,
there's specificity, right?
well,
If
there's
there's
that.
specificity where we talk about a specific behavior, maybe a specific party, and something that overlaps with enough, then you could say it's kind of a bit more relevant than just an expressive statement, right?
Yeah,
It becomes more than that.
right. So that's something that stood out to me because I thought that was pretty telling. I was like, wow, this is happening here in Atlanta, but it did not sink in, I admit. So whenever that was, when they were reading the rap lyrics, I think people were laughing because 88 Love was reading some of Young Thug's lyrics. And apparently
Well,
it
and
just sounded,
Glanville did too at one
oh, was it
point.
Glanville? Okay, maybe it was, okay. I know they were reading
I
it in
think they
open
all
court
have.
and apparently it sounded crazy. But, so that was one of the first times that really stood out to me. And then I realized that the case is still going on. I'm like, wasn't that like 10 years ago? What's going on? So I'm looking forward to seeing how this ends, but I do think we've seen the end of it. I think,
Yeah, I'm leaning way more towards that. And
yeah,
again, I'm 100% thinking it should end. And honestly, I think I'm more than 50%. I don't know. I don't
well,
know if it'll end quickly, but if a recusal hearing, the resolution there, if that's not favored, then how quickly will that get to an appeal? And will the proceedings continue to be stayed while that decision in the recusal hearing is also appealed?
yeah. So 89% of I was almost 87 people answered my poll. 88% of them said, yes, this thing is over. It's a wrap.
Yeah.
11 said no. But this is something, because I live here in Georgia. My name is Jason. I live in Cobb County, Georgia, which does have extradition rights to Fulton County. So I'm always on the lookout for Rico, just in case Fonnie Willis decides to put RICO charges on your guy. This is another case that is really, that has garnered, dare I say, global attention and is doesn't show well for Fonnie Willis and the Fulton County DA's office. Because please keep in mind, I know y'all forgot about it, but that election interference case is pretty much in the same boat as this case. It's in a stay until like October, if I'm not mistaken, October 4th. So there's a lot.
Well, and they also just agreed to let a party that wasn't part of that trial also stay their proceedings now too.
Yeah, so.
Which is interesting because you just had on Friday in the YSL trial, you have all the defendants. None of them took a plea deal. They all want to take it to trial. Now, what does this mean for their proceedings?
Yeah. So I just don't think that this looks well for Fonnie Willis's DA's office. I think, first of all, I don't think that RICO charges should be able to be brought up by the state. I think there should be federal charges from the word go, because feds are able to handle that at a much higher level. This is literally choking Fulton County. I mean,
Yeah.
now, because many of you might not know, Fulton County brought up 160 teachers back almost 10 years ago on what's called the Atlanta cheating scandal, where teachers were adjusting, shall we say, standardized test scores so that their children were better performing because they had paid for performance in Atlanta Public at that time. And literally last week, they were doing away with some probations. They had teachers on 20-year probation. It was craziness. So they brought up 160 teachers. They cleaned it out to about maybe like 117, 116. And so many went to court. There's like 30 of them or so that went to trial and were found guilty. And they're under probation, so on and so forth. Literally last week, they were still clearing out that, and that's that's almost 12 years ago. So
I think Dennis Byron recently covered something like that too. He had some of the teachers, he recorded them speaking at a hearing. That was like last week too.
Crazy thing is, I went to school with some of those teachers. So when we hear this kind of stuff like this is choking up Fulton County. I'm sorry. This is literally strangling Fulton County. These type of cases, I don't think that these should be state cases. This kind of stuff should go straight to federal court and let the feds deal with it, and however they choose to. But it shouldn't be a county thing. But I think it's showing Fonnie Willis's and the Fulton County DA's office their lack of ability, because look where we are right now.
Yeah. All while, and if you bring it back to the transcript, all of this while you have someone saying, I did the crimes, and then he's the one with the immunity deal.
So let's say this. So let's say he did say, I killed Nut, and he had immunity, because she asked him like twice, if I'm not mistaken, on the last time Woody was on the stand. She asked him twice, did you kill him? So what if he did say that? Like, okay, fine. I'm going to give her this straight up lie. And I'm just going to keep lying. So if they ask me, I'm just going to say, yeah, I did it. That would have thrown the whole thing into a tailspin for sure. But he already had immunity, so they couldn't have done anything. And by the time they did the research,
well, I disagree. I disagree, because the way I look at this transcript, I look at it as he believes that they would still prosecute him, but knew he had to go and testify anyway. So he made his decision in the ex parte meeting. I'm going to get up there. I'm going to throw in some I don't recalls. And I'm just going to say, I'm going to lie when I know it would put me in contempt. So I can't trust that his response is truthful, because look at how he turned around. Put me up there in my clothes. Let's just do this.
I agree with you. So definitely no disagreement. I'm only wondering if let's say he did trust them. Do you think he would have done that? Like, let's say for whatever reason he does believe that DA Hilton, DA Love were going to do the right thing. ADA Hilton, ADA Love, we're going to do the right thing, and they weren't going to throw him in jail. Do you think he would have said, sure, I killed Nut? Man, this is what I did. And just been lying? No? Okay.
No. Because I still don't think you'd feel safe from someone else coming to prosecute you.
That's fair. Okay.
What if you even in the same district? What if like Love retires, Fonnie's kicked out, as a whole new DA comes in, and they're not the one that made the promise? They tell someone in another county. You think what he's done is only limited to Fulton County?
That's fair.
And I know they said the state won't prosecute you, but what about a federal level?
And I think that was my question before, was what about the feds? If you have state immunity or county immunity, but if the feds hear you do something, drug smuggling or whatever like that, can they do something about it even though you had immunity with the state? So I think that was also a problem too, but I didn't hear it in the transcript, or anybody voice it rather in the transcript.
Well, and that's why I hated that Hilton got cut off. I just pulled it up, but she said, she was explaining to Copeland, she said, if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds, and then she got cut off.
Oh.
So I was like, why did she say the feds? It was on page 24, by the way, line 17, if anyone's like looking at the transcripts. I just made a OCR version that's scannable and searchable. I'll have to upload it to a Google Drive because I don't think the file that we have is searchable to find a word on page.
Gotcha. Okay.
Let me go upload a new one. And I'll give you the link you can share out to the chat. That way you can like Control F or Command F to find keywords
Absolutely. Yeah.
anywhere in the page. Big help when you're dealing with like longer documents.
All right,
And I
so
pay $19.99 a month for Adobe, so put it to use.
use it. Put it to use. Put it to use. All right, where are you gonna drop it?
Let me make sure I share it so anyone can view it. And
Email it to me. Okay,
yeah, let me do that because I think it was messing up earlier.
Let's just blame it on Jason. It was user error. Let's just blame it on me. I'll take it. No problem.
Okay, just emailed it.
I love it. All right, and I'll drop it in the chat.
Oh, wait, I think I might have uploaded the wrong file. Hold on, I uploaded the one that wasn't OCR'd. Well, give me a minute.
That's all good.
It takes a few minutes to reconvert it. So, sorry, what were you saying?
I don't remember what I was saying. No, I totally get it, and I think that, say again?
The feds.
Yeah, I do think the feds would have been a real issue. I see here, so I'm not going to, not this one that you just uploaded, so I won't, the one you just sent me, so I won't drop that link.
Yeah, that one's not the searchable one. It takes like a couple minutes to like scan, because what it does is it scans the image and then tries to extract text.
Yeah.
And then converts it to something that's searchable, so it takes a couple minutes. I had done it, and then I don't think I saved the right file. I think I closed the program instead of saving the OCR'd file.
Let me just check real quick. Yeah, this is the original. Yep. So let me do this. Let me drop the original in there, just so they all have it. And then I'll drop the edited version, the one that is searchable. So here is the, if you were looking for the transcript, here's the transcript right there in the chat right now. And Kat, not Williams, is doing a great job of making it searchable so you can do Control F to search for keywords or phrases, whatnot like that. Is that fair?
Yes.
Okay.
That's what I'm working on.
And she's doing it now. She's diligently working at that. And I'm diligently trying to figure out why I couldn't do my share screen. But we'll figure it out. I don't know why. But okay, so tomorrow, what's going on tomorrow? What do you think?
I mean, nothing. I mean, the next thing we have to look for is motions being filed or proffers being filed. I mean, people are, there's going to be action in response to this transcript.
Oh, no question.
Like now that the facts are no longer just upon information and belief.
But now, yeah.
This is something that's on the record.
Is it fair to say that we're going to have YSL withdrawal?
No. We're going to get a bunch of motions. I have no doubt in my mind that we're going to get a bunch of motions.
Oh, there's going to be motion in 10 minutes. But again, like most of us are used to like sitting here watching this for 6-7 hours a day. None of that now. I mean, motions are real though, but I do think without being able to sit here for 6-7 hours a day, I think most of us are going to be traumatized. All right.
Sorry, I'm saving this now. And I'm going to double check and make sure it actually
works. Yeah.
Became searchable. Because maybe they did something to make it so it couldn't be converted, but it didn't give me a message saying that. So I don't know why it would be acting funny. Okay, this one works.
Okay, dope.
Just checked it. Let me upload the correct one. And this one has an SS at the beginning of the name. So if you downloaded the other one and you go to download this one, you'll be able to tell the difference. Give me 1 second and I'll email. Okay, so the new one is now emailed to you.
Love it. All right.
And I'll also tweet it out or whatever.
I like it. Real quick, what is your email? I mean, your Twitter, so we can make sure we follow you there as well.
Oh, it's Cat Not Williams, but the O in not is a 0 because Cat Not Williams was taken.
Got
So
it. Okay, so this is the. I don't think. Okay, so I'm just double checking real quick, make sure this is the right one, and it is.
okay.
Okay,
Control
cool.
F and look for the word feds.
That's exactly what I did. I was looking at Copeland. I was using Copeland, but yeah, this one now. Earlier, I dropped the link for just the transcript, and now I'm dropping the link for the transcript in the chat. If you want to do your own research, there it is right there. Thank you so much, Kat Not Williams. I appreciate you.
No problem. 10 times easier when you don't have to scroll looking for something.
I agreed. So Ken said, y'all heard it here first. Motion for mistrial, motion to dismiss with prejudice on double jeopardy grounds due to official misconduct. Where is that, Ken? I totally can agree. I believe it. But where is that? Because if there's time, we can check it out. I don't see him commenting yet. Thank you so much, Transplanted Texan. Just gave a little thumbs up. Let everybody know that that is the transcript right here. If that is searchable, so now you can go in there and just hit Control F and find what it is that you're looking for and see what's going on there. So thank you so much for that, Ken, as well as Transplanted Texan. Thank you very much. Here is Kat Not Williams' Twitter. Thank you, Smile Wolfette. Kat Not Williams, and the O in not is a 0. I love it.
And shout out to Smilin. Smilin is the one that pulled the summons when the writ was filed with the Superior Court. And that started the little chain of event because I saw the case number was different, pulled up the case number, and ended up seeing that it was assigned to Belinda Edwards. So that was like a great thing to realize Friday. And I think if Smilin didn't send that summons, we wouldn't have realized that because I sent it over to Thugger Daily after that, and everybody got wind of it. But today, Judge Glanville in court was just like, I'm going to take these recusal motions and I'm going to be the one that sends them. Right. Which is true for the ones that weren't sent over, but he's not the one initiating it on his own organically.
That's correct. He was strongly encouraged. I do like how he was trying to frame it like he was in control of it. Like, Judge Glanville, just let it go, my guy. Everybody knows what's happening. Just let it go, my guy. But it's under Fulton County's page. Okay. I'm wondering, is that
I think for the summons, you can pull it up if you go to like the Superior Court's e-file for criminal cases, their magistrate page.
I love it. Okay. All right. Kat Not Williams, thank you so very much for being such a great co-host on this. This has been fun.
That was awesome. What a day.
What a day. What a day. All right. So tomorrow, since we don't have YSL coverage, I guess we'll all be just reading briefs and proffers and motions. So get your reading glasses on, unlike myself. But no, that was dope. Thank you so much. I appreciate you for being kind and coming in. Thank you so much to everybody. Belinda's already sent him a notice to respond. I wonder who.
Yeah, the summons.
Oh, okay. And that's to Glanville?
Well, it's like kind of like automatically with the filing. It was you would also attach the summons to give notice of the filing to a party that needs to respond. So since he was named as a defendant, the summons was also filed, so he would be notified of this mandamus hearing.
Wow. Okay. Got it. Okay. How about this? We never talked about what happened to Mr. Tay. Woody's.
I think that sounds crazy no matter what the surrounding details are, whether he was in somewhere where Woody's attached to it or not. It's just crazy timing that this would be the time that he gets conked out.
Right.
And Woody's on social embracing and paying respects.
Correct.
For the loss. So.
All right. Well, maybe tomorrow. Maybe we'll talk about it tomorrow. You got anything going
Well, it'll
on?
be work. Guys, I got a
Right.
full 40-hour job that always seems to need me as soon as I have plans. So if you ask me for a time commitment, it will be broken. If you send
I
me a
love
link
it.
and say, "Can you go live right now?" you'll probably be more likely to get a yes than a pre.
I appreciate it, though.
They know the second I put something on my calendar, I swear.
I love it. Well, I won't put it in the calendar. I'll just text you a meeting and say, jump on right now. But
Hurry.
yeah, so we can talk about it. But I do want to talk about, I am going to talk about, please forgive me, what happened to Tay. Because I think that was really a sad story. And I do think in this regard, I think you kind of hear it even in the transcript. Woody is a means to an end. He's not a human. He's not a person. He's not a dad. He's not a brother. He's a means to an end that the state and, dare I say, even the court wants to get to. And I think that's unfortunate. And I think that's the same thing with Tay. They're just a means to an end. And I think that's part of their issue is that nobody sees them as human. So I might do that, look into that tomorrow. So don't be surprised if you see me doing that tomorrow. But all right. Oh, okay, here comes the last thing. Polemic K says the motion for mistrial will be denied at every level based on the transcript. Mark my words. The ex parte meeting will be pushed to an appellate issue after the case is resolved. Okay.
I mean, kicking the can down the road. I mean, it's not outside the realm of possibility. And I don't really think that that's I don't think it being kicked down to the appeals court would be surprising. Although it'd be disappointing to a lot of people. I don't think it'd be surprising to a lot of people, if that makes sense.
No, I got you. The only reason is, in my opinion, it would be such a massive, there's such a hole in this ship to think that you're going to bring it to a harbor and repair it and then still sail across the seas is a silly argument. Like, I disagree. I don't think that I think this case is over. I think it's over.
I hope it is. I think it's way more of a chance to be over than obviously ever before, but really for any other, I don't know. To me, this is like there's a case down in Florida where they found out a prosecutor was speaking with a jailbird, like someone that's been in jail for 10 years, but they used them to get statements when they need a statement and just promised them better conditions in the jail.
Oh, wow.
Michael Von Zompt was the prosecutor's name, and he just got the boot from getting caught doing just that. And it was just a rare thing to hear because sometimes you hear about jailhouse informants or testimony from someone in jail that may not be credible, but a prosecutor uses it anyway. And then the courts will say, well, the jury's the fact finder. The jury's the one that gets to decide if that jailhouse testimony is credible or not. And they don't want to touch it. They don't want to appeal, say that's error. They don't want to grant a retrial and send it back down to the lower courts to retry on that type of issue most of the time. But here I do think it's so far blown out of the water. You have the transcript here. I don't think the transcript is exonerating to the prosecution or the judge. And even if the judge in these recusal hearings wants to kick the can down the road, I think we're going to have new motions filed, renewed motions for mistrial.
Oh, yeah, for sure.
With this stuff for the transcript. I mean, there's going to be so many moving parts that I can't imagine this trial, in the best case scenario, if no motions were filed, would even get back on track in the next 30 days. But if you have additional motions being filed, I don't know. How can you call a break for more than 30 days, more than 60 days maybe? Pause a trial for that long and then just have the jury come back in and pick right back up.
And please keep in mind, they've been out for 3 weeks already.
They can't just go apply for a job and say, well, I want to work until I go back to jury duty.
Right. Until I go back to jury duty. And then also you'd come back in from jury duty and you may potentially have a different judge. You may have different key players and such like that. And there's no way you can believe that they're not actually engaging in social media and hearing what's going on and seeing what's happening in the newspaper and so forth, especially if you live here in Atlanta. It's everywhere.
Yeah.
I mean,
And that
like,
that might work in the favor of a mistrial being granted, right? Maybe even if they would normally pass the buck, kick it down the road, maybe they'll say in this instance, look, there's just too much spotlight on this right now, and
too much
maybe
heat.
that gives it a more favorable actual possible mistrial will be granted. I mean, I don't really know.
No, I
I'm
think
kind
it's
of disheartened. I'm pretty pessimistic about the idea of a mistrial being granted,
right.
but I'm optimistic because of the underlying circumstances here, the unique situation here, plus the spotlight that's on it. So I've got a weird conflicting balance of optimism and pessimism.
I love it. Well, I appreciate it. All right, everybody. You know what? It's time for us to get out of here. It's
It's
11:30.
time.
It is time. Everybody, I want to thank you so much. Kat, do you want to say anything before we leave? Anything about your channel?
No, thank you so
or
much.
what you're working on?
You guys can come find me at Cat Not Williams. Just search on YouTube in the search bar, like Cat Not Williams YSL, and I'll come up. But I want to thank
Absolutely.
you for having me on, and I want to
Oh,
thank
this
your
is fun.
chat. Your chat is so hospitable. Your mods are so hospitable.
They're the best.
I love being on the side of the chat, and I'm really honored to be on the screen with you,
Well, I
having this
appreciate it.
conversation. Yeah.
I really do appreciate it. Thank you so much, everybody. Whether you're part of the Cat Army or whether you're a regular on Dear Woke Christian, I want to thank you all for hanging out with us tonight. It's been a long night, but I'm looking forward to a great day tomorrow. So you all do the same. And until next time, everybody, grace and peace. Take care.